top-driven approach that helps. But we all believe that ours is a federal system, and we know that it is not only top-driven, but it is also laterally driven. And that is what is the beauty of our country. And that is the reason why we actually celebrate being republic in a very big way on the 26th of January every year. And why 26th of January? We actually celebrate the festival of democracy every minute in our lives. This is also, therefore, a very democratic process that we are going through today. Asking for public comments a lot of times is seen as quite a customary role that the government is playing. And people think from outside that it has got really nothing to do with the government functioning, because it is more of a customary thing that you're doing, and it is probably an eyewash. But we as professionals who has really worked in close circles with the government in one way or the other, we have seen and understood that no, this process is actually not merely a copy-paste function, but it is actually a function which is deeply taken care of by the government. So therefore, today we are actually participating in this event. It is actually an ardent duty that we are doing towards our nation. I have muted him. So today, without much ado, I must do the honors. We have Anilji, who is definitely doing a lot in this space, who's a
See, you have to unmute yourself.
I'm so sorry. So Anilji, I spoke about you. I hope that was heard.
No.
No. Oh, I must do that again. Because
Mamta ji, आपकी ना आवाज echo कर रही है. I think you get connected by 2 points most probably.
No, I haven't. I don't know why. I'm only connected through one.
Now it's okay.
To us, it is not echoing.
Okay,
For us, it is okay. Maybe some different issue.
I mentioned that without much ado, because there's so much to discuss today and so much to discuss, and then actually not spilled over, but we need to really concretely design and send it to the ministry. So we should straight away get into the program. But before that, let me do the honors by mentioning our gratitude to Mr. Anil Goyal, who always comes in an ardent way to all of us. He is, of course, an authority in himself. He's working in this space so much, and he's quite a celebrated figure. Thank you, Anilji, for being with us and sparing.
Thank you very much, Mamtaji, for all this.
All the AAA in the background, we know one particular thing. Your organization is a AAA organization because it belongs to you, and you are mentoring that organization. So for us, a big thumbs up for whatever you're doing.
Thank
Mr. Nilesh Sharma. Thank you, Nilesh ji, for always standing tall with the organization as being one of the founder members of IPA. Apart from that, Nilesh ji is also a great professional in his own rights, and he has been a very well-known figure in IBC from day one. So thank you, Nilesh ji. And there we are, seeing a very handsome man there, Manoj ji. Thank you for being the president of IPA, Manoj ji, and not only being in the books, but actually steering it forward. I myself understand how much it takes to do things, and we've always been in the forefront, taking the objectives of IPA forward. With this, let us immediately give the baton back to Manoj ji. Manoj ji, you can take it forward from here, and let's see how we can frame this up going forward.
Manoj ji.
Manoj ji, over to you.
Yeah, actually, something wrong is going on, because on my side, voice is being echoed, and what you are saying to me is being get repeated. But this is good part that it is not being echoed to the others, to all other audience. I think I'm audible.
No, I think Manoj ji, you would not be feeling comfortable, and I think once you should be disconnect and then join again, it will be corrected hopefully. Otherwise, with echo, it will not be comfortable for you to speak.
Okay, in that case, I have to end the meeting because I am the host.
No. You see, like you can exit by assigning it to another person.
I'm there, Manoj. You can just exit and come back.
If it is okay, then you can continue.
No, I think it's better that you said that because he was not feeling comfortable at all. So I'm sure many comments may not have yet reached the ministry because it is always towards the last date that we start sending our comments. So I think 6th and the 7th being the last date, 6th and the 7th will be the 2 days when ministry will be getting the comments. And I've already understood that lot of even people from the industry bodies are also giving their comments because IBC has become one law which is not only there for the professionals, but it is basically for the restitution and resurrection of the industry. And therefore, industry body is also thinking about the MSME sector. And as we have seen how MSME sector is already the backbone and how the ministries, and especially in this budget, we have seen that I'm sure you may have seen in the budget that if we are not paying the MSMEs on time, that expenditure will also be disallowed. So there is not much which the government is doing for the MSME sector. I think if Manoj is in, yes, Manoj.
Yeah, I think I'm audible now.
Absolutely.
Yes. Yes.
Thank you very much. We are not so technocrat. Such sort of disturbance do creep in, even if we won't desire, because we manages everything at our own only instead of hiring some professionals for this purpose. Okay. Thank you, Mamta ji. Thanks for the brief introduction. I would like to start very quickly. Only few words I have to say for all the people sitting here. First of all, I would request everybody that let video be on. In that case, we feel that we are interacting with each other and we love to interact with each other. और हम सब लोग maybe हम लोग 4 host हैं, लेकिन हम 4 ही host नहीं है, सब host हैं. और panel के अंदर we needing a lot of your contribution also. I request everybody to on their video also. I extend saying of Mamta ji and say that successful people can't relax on a chair. They sleep, awake, achieve their goal in their chair only. That's the spirit of IP also. We need to work 24 into 7 hours. Although at this time, at this moment, Mamta is also just sharing that budget 23 is the buzzword. But for as an IP we are concerned, जो हमारा 18/1/2023 का notice आया है MCA का for invitation of public comments, I think it exceeds budget in many aspects. Reason for that is कि budget तो हर साल आता है. It has come after 6 years, and it has, everybody knows that it has a lot of changes. We need to deliberate on it and require a lot of understanding so that we can give our input to the MCA also. Because, the reason for that is that the kind of input which we shall give to the MCA, accordingly, they will come out with a draft bill. And when they will come out with a draft bill, at that time, we shall also have an opportunity to say something for, against that draft bill also. But that draft bill genesis will be the input which they will receive from from us. If I see broadly, changes brought in this paper is that either to overcome some judicial pronouncements or to take care of some things which are already there in regulation, just to fortify it more with the code and this thing. That is the main thing. Now, without wasting much time, one thing more I would like to add there is that earlier we used to have a lot of advocates on our panel, but this time we thought of let's have IPs only in our panel so that concern of the IP is taken in a better way as far as IBC this public comments are asked therein. With this, I request I forward to Nilesh Sharma ji, and then I request Nilesh Sharma ji to welcome to Anil Goyal ji and start the proceedings.
Okay. So I again welcome Mr. Anil Goyal, Mamta ji, and our Manoj Kumar ji also, and all other participants on behalf of IPA. And now I think, Anil ji, you have made some presentation or PPT where all the proposed changes are reflected. I think we can start with the same. So, so those will be there on the screen, proposed amendments. We will make the discussions, all of us. And then I think participants can also offer their views if they are having any. So we can start with that, Anil ji.
So thank you very much, Nilesh ji. Thank you, Manoj ji. Thank you, Mamta ji. And I think this efforts made by AIIPA and also NCLT Kolkata Bar, where Mamta ji is the leader, and Kerala Insolvency Professional Forum also, and there should be some representative from that forum. JIPA Professional Association is also co-hosting this particular webinar. So as I think Manojji has rightly said, there are certain some amendments which are targeting at diluting the impact of some of the Supreme Court judgments, and there are some amendments which are basically regularizing some regulations which are already made. So this is the effort that has been made in this proposed amendment. By way of a notice, it has come to us dated 18th of January 2023. The format that we should have for the discussion is that we should one by one, I would say that this is what is my understanding about the proposed amendment, and then on each amendment 1 or 2 comments should be taken, and then we should note down that is there anything that we need to suggest, and that's what we would finalize. I believe that there should be one person, Nileshji or Manojji, who would finalize that this is what would be the comment, and at the end of this discussion, we will finalize this is what we all have decided, that we will give this kind of suggestions if someone can note down. Although the PowerPoint presentation is something which is a little larger, but then we will quickly go through that kind of presentation, which is so we have a certain kind of topics: use of technology in the IBC, admission of CIRP applications, streamlining the insolvency resolution process, recasting the liquidation process, and role of service providers. These are the major headings which have been covered in this proposed amendments. So use of technology in the IBC ecosystem, it is very important, and this should be done. It is only a proposal that there will be a state-of-the-art electronic platform, and that electronic platform will probably have some kind of coordination between the adjudicating authority for delivery of notices, for enabling interaction with the IPs and other stakeholders, storage of record of the CD, and the process, undergoing the process. I mean, maybe this all would be something that we would see in future, that as we have this platform of submission of various forms under the Companies Act, that kind of system may evolve over a period, but this is a proposal and it's a welcome proposal. And with what I understand, that the linkages between the IPA, IBBI and adjudicating authority, and that's a very, very important, so that the that is the time, the wastage and duplication is not something which is appreciated. Now, one of the very, very important
सर इसमें एक थोड़ा सा मैं ऐड करना चाहूंगा। ये जैसा अभी सर ने बताया कि यूज ऑफ टेक्नोलॉजी इन द आईबीसी इकोसिस्टम, इसके ऊपर आईबीबीआई ऑलरेडी वर्क कर रही है। इन्होंने आईबीसी 21 करके एक प्लेटफॉर्म बनाया है। सिमिलरली एनईएसएल इसके भी ऊपर काम कर रही है, एंड दे आस्क्ड अस की सजेशंस कि हम इसको कैसे बहुत सारा इफेक्टिव बनाएं। तो उसके लिए डिफरेंट प्लेटफॉर्म्स हैं। इनफैक्ट हमारे पास भी ये वी थॉट ऑफ गिविंग देम अ सजेशन। सम एडवोकेट्स हु आर working in Delhi, they say that this sort of system is very good working in Delhi High Court and other courts also. And since we come from the taxation background, so we feel that such sort of system is very good working in the taxation department also. Interactive system, whatever their name is there. तो एक ये भी इसके अंदर है। तो हम पार्टिसिपेंट से ये रिक्वेस्ट करना चाहेंगे, इट हैज बीन आस्क्ड बाय द IBBI chairman to us also, कि अगर इसके लिए कोई भी अपनी इनपुट देना चाहे, where they can help to the IBBI for developing a system for use of technology, he is most welcome. Sir, sorry for interrupting you. Now you can move to second topic, please.
No, that's fine, Manojji. That's a very additional information that you have given, that the work has already started. It is not called interruption. It is called adding further information for our audience. See, the amendment which is proposed for like increasing the reliance on the records submitted to information utility that is also one of the proposal, and it is proposed in this manner that all the financial creditors and all the operational creditors would be required to submit the information of their debt and then the default, and that would be submitted to information utility. And then the record of default that would be submitted to adjudicating authority along with the application. Yep. And that is what is the proposed amendment. Our observation in a couple of meetings that I attended in person at Mumbai also. So one observation that we have is once this kind of law would be notified, then whenever any information would be submitted, for any debt to the IU, and that would be known as if that would be thought as if the other person is trying to file an application under section 7 or 9. Although for section 7 the banks are already doing this, and therefore but it will become actually very important for section 9 application that the IU information and record is available. So what we observed that everyone submitting information of debt or default that would be disputed by the corporate debtor, that would be disputed by the company always. And then when the application will be submitted, after this, the application will be submitted under section 9, then every company will say that the default or the records of the IU, they are showing that there is a dispute going on. So most of the section 9 applications will actually be showing some dispute, and that dispute would be even prior to the service of notice. Even prior to the service of notice, this dispute would be there on some of the public platforms. So this is a difficulty, and we could not find any solution to this, because see, as we understand, the IU has system that they will give further they will communicate with the debtor, and that debtor will say it is okay or it is they will dispute it, and then they have some color coding, some yellow, green, and red, and based on the color coding they would finally decide whether the default is there or not. But however, in case of a response from the company, in case the company or the debtor say that it is disputed, and the disputes can be of various kinds. The debtor can say that there is a dispute of delayed supply, there is a dispute of quality issue, there is a dispute of late supply, there is a dispute of price, there is a dispute of numbers supplied. So these are all various kinds of dispute, and how the IU would adjudicate it and how the IU finally would record the default, that is something which is not yet clear. My understanding about this particular provision is that we are in fact increasing the litigation of dispute rather than making it easier. Whatever time it used to take before the adjudicating authority, the time before the IU would also be added further, because before the IU, every debtor will say that this particular payment is disputed. So any comment on this, Mamta ji, Nilesh ji, Manoj ji, so that we can guide our audience that what kind of suggestions that we should make, because as such, I feel that it will add to further litigation regarding dispute.
Now, sir, I fully endorse your view. In fact, in my opinion, also it is an overreach, overreach by the MCA. That because if we see in the past also, even for Section 7 application, which was that has not been a very successful with IU. How we can expect that Section 9 application will be equally successful? And secondly, आपने सर बिल्कुल ठीक कहा कि we can't expect कि IU to act as a double A. because what is expected कि जैसे उन्होंने accept कर लिया within a particular time उनको कोई reply नहीं आया, then it will be deemed that this is a good debt. That adjudication will always be challenged in the court and will never be acceptable to honorable courts. तो इसके लिए सर in totality comment यही हमारी तरफ से जाना चाहिए, the audience can also add to it that this sort of practice or bringing this thing in the law will not be good for the IBC 2016.
So this is what is our opinion. Our understanding is concerned. There is no gap in the understanding that this is what is the record, that the applications under section 7 or 9 would be required to be submitted. However, they have also given an additional option, and that comes in the paragraph as, however, there may be circumstances where the records are not available with the IU. In such limited cases, the adjudicating authority, on genuine reasons to be shown, may consider other evidences. So this kind of window is also available for some cases. But however, this window is not available. This is not mentioned that if prior to the issue of notice, if there are disputes recorded on IU, or how those disputes will be adjudicated by IU. And then the IU will always give a certificate of dispute with an asterisk that there are disputes in this matter. So that kind of certificate, would it really helpful in section 9 applications? That's what is my apprehension. So we can move forward and say that it is mandatory to admit applications under section 7. And this is again the impact of Vidarbha Industries Power Limited versus Axis Bank. That is to be diluted in this case. The word mentioned in section 7 subsection 5 as may, that will continue to be as may. However, the confusion regarding the scope of the adjudicating authority's discretion is not, it is clarified that the adjudicating authority will not delve into the detailed factors relating to the solvency and financial health of the corporate debtor. This is not required by the adjudicating authority as per the original intent of the law. So once this clarification will come, that means that the adjudicating authority would not have any jurisdiction to reject or admit an application based on the factors or circumstances regarding ability or inability of the company to pay. So therefore, this amendment would be really a very, very kind of welcome amendment. The only thing is that they are not proposing this word may or shall. They are saying that the only thing that the adjudicating authority would look into whether there is a default or not. That's the only amendment which is proposed in this.
So I think I don't know how they are going to do that, Anilji. I think they may substitute the word may with shall, or otherwise some explanation may be there to this particular section. But no doubt that it's a welcome move, or it is a welcome proposal that adjudicating authority should not have that discretion. If it is proved that there is a default, then the matter has to be admitted. The application has to be admitted. Because that is the definition of an insolvent company is that when there is a default of more than 1 crore of rupees, then discretion should not be there. Otherwise, in all the cases, the corporate debtors, they will be raising one ground or the other, and it will be difficult for adjudicating authority in that case. If they give some particular decision which will be challenged before honorable appellate authority or appellate tribunal or before honorable Supreme Court. So I think it's a welcome proposal. And NCLTs, they should not have any discretion in this regard. If default is proved, then they must admit.
So I would like to add, Nileshji, what you are saying. I would like to
can
add,
you move to your previous slide, please?
Yes.
Yes, sir.
So I said I would like to add that in case this kind of amendment is not done, then what will be in store for us? Then for each application under section 7, the companies will argue before the adjudicating authority that they are asset rich, it is only a temporary fund flow mismatch. They are undergoing a restructuring proposal, which is a better option. They are undergoing a one-time proposal, which is a better option. They are getting an investor, and that investor is bringing this much of amount. That's a better option than insolvency. So these kind of arguments, in fact, it has already started coming in. And then they will also come. Most of the infrastructure companies will come and say that the kind of default that we have, and we have the matching or better number of our claims in arbitration. So once we get our claim, that means that the company is fully solvent. So this was my apprehension. So this amendment, in fact, is a very, very welcome amendment.
Definitely. And Anilji, I also want to say something here, that as we know that earlier law, which was Sikh Industrial Companies Act, their definition was based on balance sheet definition. That was a definition based on balance sheet, where net worth is negative, then you were treated as a Sikh Industrial Company. Here, our definition is not net worth based. Our definition is based on cash flow. Our definition is based on default. If there is a default, then you become a insolvent entity, and then you have to go through this process of insolvency and liquidation. Your assets may be, suppose for example, if your assets are worth 100 crore and your liabilities are 20 crore, but you have committed a default, you are bound to go through this process. So it is not that because your assets are more, then you should not be, so that, because that is not our definition. So I think it's a good proposal, and I think we support this amendment. Yeah.
Sir, I would like to little bit deliberate on this timeline of 14 days also. Because we have seen that this directly timeline, let's have some deliberation and talk on this also.
No, it has also been, maybe a couple of judgments might have been seen that the adjudicating authority has said that the wording mentioned about 14 days is that they have to, in the 14 days, they have to ascertain the default. It is not mentioned there as if they have to admit or reject an application within 14 days. So there may be a change in that. Instead of 14 days time given for ascertainment of default, it will be mentioned in this section that it is the 14 days time is for admission or rejection of the application.
But sir, here my submission is, Nilesh, please carry on.
Manojji, I think, and Anilji, I don't know whether it is possible for the adjudicating authority.
This is my point also. It is not practically possible. And, you know, the bringing a particular timeline, which is not practically possible, we should tell to the government that instead of making all these timelines directly, let's make it, make it practical. And instead of 14 days, let 30 days time, initial applications come out to be there, notices being issued, comes after. Let some practical timelines be fixed therein, so that say 30 days or 45 days, and that 30 or 45 days should be made mandatory, not at all directory. If that sort of amendment we can suggest, or something like that, that is in my mind.
Even though that type of amendment is made, even if this particular section, the word shall is used, that they will be deciding that application, decide the admission or rejection of that application. But still, I think Honorable Supreme Court has earlier held that these timelines can be directory only, because these for an adjudicating authority, you cannot, I think, impose this type of timeline, considering that a number of factors are there which are beyond their control. Suppose corporate debtor, you issue a notice to the corporate debtor does not reply, or he attends the hearing, he seeks further timeline. So what will the court say? Court will still admit the application without giving an opportunity, which is called natural justice. So I think on that ground alone, the corporate debtor will be going to the adjudicating, to the appellate authority. So I don't know, even if this amendment is made, whether we can make it mandatory for the court. So that is, I'm having my doubts about that.
नीलेश जी, मैं उसी करके मैंने कहा कि ये 14 दिन की जगह पे let there be 30 days or 45 days, and similarly for other prisons also. I'm not saying this thing for the, because when such sort of stringent prisons will be there, because I tell you one thing, in our taxation practice we see that whenever anything time barring is there, everybody adhere to it, whether it is a department or assessee. Similarly, if some critical sort of things are there, Supreme Court may have a lenient, observation on that account also, by saying this thing that earlier we understand that 14 days line was days were not practical, but now 45 days or 30 days or maybe what on the average time is consumed there, and now we can't give you relief by treating it as directly in nature instead of mandatory. Because sir, why I'm saying is that because IBC ka your preamble that preamble means timelines. Sir, you have seen, we have also seen that 180 days or 270 days it has gone in haywire, and it has gone in haywire mainly because of the more time taken by the adjudicating authority, either in addition of the application or in the disposal of a registration plan or maybe some other things also. If we can have some sort of suggestion on this ground also, taking it as a base, I feel that we can think of.
So this is one thing, that making this type of mandatory timelines for the adjudicating authority. And we know that the admission cases are being taken on priority basis by different benches of Honorable NCLT. But I think more important is approval of resolution plan. We have filed application for approval of resolution plan before adjudicating authority. If you want to fix up the timelines, mandatory timelines, you fix up regarding approval of resolution plan. I don't know whether in these guidelines any such proposal is there. So I think do that more than the admission. Important is that approval of resolution plan should be made rather than admission. You are admitting these patients in a hospital, but you are not curing them. There is no timeline for curing those patients. So I think admission rather than the admission, important is closure of the case or approval of resolution plan after an application is filed before adjudicating authority, and then some timeline should be there for approval of the same.
Now, what suggestion?
Good evening to all of you.
Yes.
Sir, this is Anuradha Bisani. Just to add on to this, sir, if suppose you are making any such kind of recommendations for NCLT, timelines, also please include that once the orders are reserved for, once the orders are reserved, the pronouncement also should have some timeline. Sir, I have cases where it's been 2 years that it is reserved for orders and it is still not pronounced.
I think, Radhaji, the timeline is already mentioned in the NCLT rules.
Yes, sir.
They are supposed to give an order within 30 days of the reserving, and then they can also, I think, further it can be extended by 15 days. That is there already in the rules. Now,
sir, but aisa ho to nahi raha hai, sir.
So, which is the timeline which is applicable to adjudicating authority? Is there any timeline which is being honored by them? Like they are saying that we have pressure, we are working, and the second is that in case we make the rules in such a manner that if within the 14 days, if the NCLT doesn't have time or they are occupied somewhere else, or the respondents are not even responding, the respondent lawyers are not even coming, then in case the company goes into insolvency, like for example, I can tell you, like somebody can file an application under Section 9 for ONGC, and the notice is not served on them, and the ONGC, the law department is somehow not alert. Do you think that after 14 days we should admit ONGC into insolvency? Do you think that it is right? Just
No,
if
sir.
we,
I'm only talking about reserved for orders, sir.
no, I'm only trying to say all the
Yes, sir.
timelines. So when we talk about all the timelines,
Yeah.
so like, see, when we talk about Income Tax Act, in Income Tax Act, we are proceeding against the assessees. And in case we don't have time to proceed against the assessees, then the department will lose their right to proceed against assessees. These are the timelines in income tax. Now, in this case, it is the two parties. Two parties are somehow, they have some dispute or they have some issue. One applicant and one respondent. So the applicant files an application and the court doesn't have time. So that means the other person gets the benefit. Now, when we compare it with the income tax department or GST department, where it is very clear that if the department has to take action or proceed against an assessee, there has to be a timeline, and beyond that, the assessee is not liable to pay. So that is where the department will take the loss. Now, when there are two parties, one is a bank or one is another creditor and the other is a company, when in between these two parties, can we really apply the income tax rule? Because in income tax rule, always for any kind of delay, always the department will lose. For any kind of delay, the department will lose. However, in case of IBC, for any kind of delay by adjudicating authority, applicant or respondent can lose. Anyone can lose, and that can be even the huge amounts that they can lose, the huge reputation that they can lose. So what we are saying, all of us must recommend that when this NCLT was formed, 60 positions, 60 jobs were created for the NCLT to handle the cases under the Companies Act. Thereafter, the insolvency law came, and then the total applications pending before the NCLT, there are, like, I believe 60%, 70% are IBC and 30% is from Companies Act. I think the one sees that the capacity, the number of benches should be doubled, and also all the posts should be fully recruited. If this happens, and then in that case, these are some kind of decisions that can be taken by the government, that there should be appropriate number of benches, appropriate number of members, and also then only they can get success in IBC. Otherwise, whatever is stuck up, presently in case we are handling 300 cases, if any case is stuck up, it is not stuck up with RP, it is not stuck up with COC, it is stuck up with NCLT, or it is stuck up with any other court. So the success or the failure of IBC, primarily, it all depends upon the timeline. And if the disputes are handled and the judgments are delivered within a reasonable time, then the things can happen. But then mentioning into the act, I think it is already mentioned what else we can recommend. This is what the practically and legally, no court in the world can say that out of the two parties, one party will gain only because of the some timeline issues with the authority. That is what is the difference between the income tax department, GST department, service tax department, and IBC. I think this is what I want to say, Nireshji.
Yeah, sir, in my case, what's happening is, sir, I'm the liquidator of Lanco Infratech Limited. Okay, in this case, what happened before I took over as liquidator, there were some 30 cases which were there and reserved for orders. Now, because the bench changed, again, it was reopened. Again, it was reserved for orders. But because it was not pronounced, the other party kept on filing applications for reopening. And since it is not pronounced, again, those reopening applications have been admitted. So again, the case is coming up for hearing. So, though the liquidation process is over, but because the cases are not getting closed, we are not able to file the closure application also. That's why just a recommendation, sir, in case you're writing, or you can draft it better.
I said it is already there in the law.
Yeah, but then it is not happening. That's the point.
What else we can write? It is already there in the law. Like the 14 days are there. Other laws also, see, it is there in the law.
सर आपकी बात बिल्कुल ठीक है. तो इसके अंदर कुछ आप सजेस्ट करना चाहेंगे कि let's not compare it with
we all should time and again we should say that unless the capacity of the NCLT benches, capacity of the members, and then only the timelines will be met. They don't have time. In case they don't have time, everything will be stuck up in NCLT. If everyone will say this, everyone, then I think this message will be very clear that the capacity needs to be increased.
Okay. That is one thing. In addition, I think separate benches should be there for handling the matters, company law matters, and for handling IBC matters. And further, I think if different benches are there for handling the matters of admission into insolvency, admission and for approval of resolution plans, if we have separate benches, I think that will be better, because specialization will be there of the bench, and I think they can dispose of many matters, I think, with a greater speed. But still, let's see if we can make this type of suggestion. And at the same time, I think for approval of resolution plan after an application is filed, though we know that problem has been that adequate number of members have not been there. So unless and until adequate number of members are appointed, I think they can't handle, they can't meet the timelines. Honorable benches cannot meet the timelines. Right? I think it is.
We can conclude in this manner. I think we can conclude the two things. One, the capacity of the NCLT. This is one definitely a suggestion. Increase. One is the proper recruitment should be done to fill the vacancies. Increase in the number of posts. Increase in the number of benches, and filling up the vacancies. These are the four things that we need. And fourth, we can say that yes, there should be dedicated benches for Companies Act and insolvency. These are the two things we should say. Because see, Nilesh, even if the RP replacement is pending for 5 months or 9 months, that hardly, that actually will bring negativity to insolvency law.
Correct.
Not only resolution plan, RP replacement is pending, the banks will lose trust on the IBC. They will not move IBC only in case, because they will stuck up.
Definitely.
Yeah, sir. Yeah, thank you very much. नीलेश जी, आप ये points note कर लेना और हम लोग जो भी अपना dot बनाएंगे उसको अंदर देंगे. Sir, please move on to next point, please.
See, in section 10, the power to recommend an IRP has been withdrawn. There is a logic behind it, and since the COC would like to have a IRP of their own trust and confidence, so we definitely should welcome this amendment in a very, very pleasant manner, and there is nothing wrong into this.
Correct. I totally agree with this.
सर इसके अंदर आप देखिए, yes sir, please, उसी point पे कुछ आप कह रहे हैं, next point पे.
I think this is okay, but then in case you want to add something, please add.
या इसमें सर मैं ऐड ये करना चाहूंगा कि हमारे यहाँ पे 3 तरह की अपॉइंटमेंट्स होती है इनिशियली, एक सेक्शन 7, एक सेक्शन 9 और एक सेक्शन 10. अब तीनों के अंदर वी हैव सम डिफरेंट सॉर्ट ऑफ क्राइटेरिया. सेक्शन 7 के अंदर आरपी को देना मैंडेटरी है, सेक्शन 9 के अंदर डिस्क्रिशनरी है, सेक्शन 10 के अंदर आप आरपी दे ही नहीं, आईआरपी दे ही नहीं सकते. तो ए सॉर्ट ऑफ dalmia is being created, but ठीक है, as per the objects of the law, that is acceptable. But as an IP, when there are inbuilt provisions of replacing an IRP or converting IRP to RP, this sort of thing, although they have explained in detail in the paper also, we want this thing so that the independence is maintained like that be there. In any case, if everybody is okay, but I was having a little reservation for that.
I think I am having one suggestion here, that even in the cases of section 9, I think honorable bench or honorable NCLT should have that discretion, or rather they should have that responsibility of appointing the RP in place of a creditor, small operational creditor recommending one IRP. And what happens is that his IRP, he makes everything to see that to blackmail the corporate debtor. So I think in the case of section 9 as well as in section 10, IRP should be appointed by adjudicating authority only. Anilji, your view on this?
No, section 10 it is all right because this is an application from the corporate debtor. But then section 9 it should be optional because see, there are people they don't want to, because see, section 9 was drafted in such a manner that if there is a default, it is an obligation on the operational creditor to immediately bring it to the public domain that this company is in default, and the fee was also kept as the lowest 2,000 rupees. And in case he takes any consent from the IRP, it was also thought that the IRP will also ask for some signing fee. So therefore, the effort was made so that the operational creditor, they should not hesitate in bringing it to the public domain, that the company is defaulting and the CIRP may be commenced, because they wanted to make the section 9 application as the cheapest application. Only cost is 2,000 rupees. So this was the intent. However, section 7, when the creditors are financial creditors are appointing, they have to decide about the size of the company, complication of the process, that may be locations of the company. So NCLT picking up any name and then the creditors will meet and they will change it. I don't think that actually will resolve anything. they can, that time can be saved in case the creditors have thought before filing the application that who would be appropriate for this kind of large case or complicated case. That option should be there with the creditors. I do not, in section 7. In section 7.
Yes. Yes.
Sir, हम तो association को represent करते हैं. Any restriction on IPs, at least we won't be, feel good about that. ठीक है, as per law or as per circumstances, we obey and we accept your opinion.
No, you see, as an association, we also have a responsibility to let this law being implemented in a nice manner, in a judicial manner. So I believe that's okay. Now, moving forward, a very, very important amendment which can happen is in section 235A, which provides punishment, and those punishments are supposed to be routed through the special courts established under Companies Act, and these are called criminal proceedings. Although the section 236 I could not see, there is no reference of section 235 capital A. However, this is what is assumed now, that they are going to make changes, that the penalties of this kind, not only section 65, but the penalties can be imposed for various defaults by the adjudicating authority. Now, in case we see sections 68, 69 to 77, in all those sections, there are some non-compliances and there are some penalty and there are some imprisonment prescribed. So there is a penalty also for non-submission of the documents by the promoters, non-cooperation, not sharing the books of account, not sharing the details of the assets. So there are penalties for all this in section 70 of the IBC. So far, there is a prosecution department before IBBI, and we all file our application under section 236 to prosecution department of IBBI, and that department is not presently very bullish in filing the prosecution to the special court. They try to understand, and then they finally say that we should do it when the NCLT will direct us. We are not doing on our own. So that kind of scenario, making this section 77, section 68 to 77, these are all sections which are not really having any impact on the compliances. So they are not coming as deterrent to non-compliances. But this amendment which is being done, this is like the application can be made to IBBI, can be made to adjudicating authority, and then the penalty, civil penalty can be imposed. So now I think that the civil penalty laws will be used by the adjudicating authority against the promoters, and at sometimes against the valuers, sometimes against the committee of creditors also. But they may also use this, because we only have to suggest that imposing a penalty to an insolvency professional should be restricted to IBBI. This is the only suggestion that we need to give. We are only trying to say that yes, the adjudicating authority will have power of civil penalty on the promoters, on the stakeholders, on the KMPs, on the valuers. But valuers also, they may say that they will get regulated by adjudicating by IBBI. But otherwise, other than this, I think the penalties can be imposed on everyone who is disturbing the process, barring the. So we all should give a suggestion that this section, whatever amendments are being made, the adjudicating authority should not have any power to impose any penalty on an insolvency professional, whosoever has been appointed as CIRP, as IRP, RP, bankruptcy trustee, and also any other role under the IBC. So this is my suggestion for the penalties section. Any other?
Yes, I have some suggestions with respect to this. First of all, this particular proposed amendment says that applications can only be filed by IBBI or any other person authorized by IBBI in this regard. So I don't think it is possible for IBBI to make this type of application in all the cases of non-compliances. How many benches are functional? We all of us know that a number of NCLT benches are there. And wherever there is an application which is filed, or wherever there is a violation of law, where there will be an application filed by IBBI or the person authorized by IBBI, I think it is not possible for them to do that. So presently also already, if there is any application which is frivolous or vexatious application, adjudicating authority is having the power to impose cost. But now what we are saying is that very heavy penalty of rupees 1 lakh per day, minimum penalty, and which can increase up to 3 times of the loss caused. Is it possible for adjudicating authority to devote this much of huge time period in deciding all these things? I think these powers were earlier with the special court, imposition of fine on this type of provisions. Let that court decide all this in place of burdening adjudicating authority with all this. And what will happen is whenever this type of order is there, then appeals will be filed before appellate tribunal, and then in many cases the appeals may go to even Supreme Court. So this entire adjudicating authority, then appellate authority or appellate tribunal and Supreme Court, I think they will be burdened with a number of further applications and appeals. So I don't support this this thing. And another thing, it says that A should also be empowered to impose a penalty where it believes that such a person has filed frivolous or vexatious applications. So what will happen is, even if suppose I want to file one application, which I believe that it is a genuine application, so I will be afraid of filing it. Reason is that I don't know whether a huge penalty may be imposed on me. So I think discouraging people for filing applications, even genuine applications, this proposed amendment will be having that effect. So I'm not in support.
Sir, one thing I would also like to add, that quantum that mentioned here, 1 lakh rupees per day or 3 times the benefit, whichever is higher. This is also, we should put on the record that this quantum is on the very high side. It should be reduced, maybe 10,000 rupees per day, or other thing though is not determinable.
But Manojji, our main objective is not imposition of penalty. Our main objective is approval of resolution plans. I think adjudicating authority, appellate tribunal, they should devote their time in doing that rather than imposing this type of thing. And already they are having power. They are already having power to impose costs. That is inherent power with the courts, which they are doing. They are doing. So I don't think that this is a step which will be, I think, in the interest of all concerned. Or in the interest of resolution.
Yeah, is quantum ka bhi iske andar add kar lena objection.
Definitely, quantum is very high.
Yeah, that you also add there.
Yes, we have to conclude that we have to conclude in such a manner that the application, if it is filed by IBBI, then this will be a non-starter. So let the application be filed by anyone, and especially the IRP, RP, or the liquidator. So that's the first suggestion. And the second suggestion, as you say, is like, although I'm not sure, because the penalties can be a large deterrent for the smooth process of the IBC and especially the promoters. So, and the other is it should not be the adjudicating authority should not be able to penalize the insolvency professional or IPE. So that these are the suggestions from my side. Anything else can be added.
Okay, sir. Let's
moving forward. This is the conduct of the promoters and all. I think that would be seen in case penalties are presently there is no penalty power with the NCLT to somehow persuade promoters and the key managerial personnel to cooperate for the CIRP process. But this with this,
अनिल जी क्या होता है, इस टाइप की कोई भी एप्लीकेशन है तो NCLT क्या है, रिजेक्ट कर देती हैं, कॉस्ट इम्पोज कर देती हैं। अब क्या होएगा, वो पेनल्टीज लगाने में लगेंगी, पेनल्टीज लगाने में भी उनको शोकोज नोटिस इशू करेंगे, उनका रिप्लाई आएगा, रिप्लाई आने के बाद में इम्पोज करेंगे, फिर एडजुडिकेटिंग, तो एडजुडिकेटिंग अथॉरिटी का इतना टाइम वेस्टेज, देन उसके बाद अपील्स फाइल होंगी। तो ये एक नया पंडोरा बॉक्स ओपन हो जाएगा। तो मेरे अकॉर्डिंग एडजुडिकेटिंग अथॉरिटी
we agree with you.
ओके, स्टिल आई थिंक वी विल सी कि क्या हमें सजेशन इसमें देंगे।
चलिए सर, ये बहुत इंपॉर्टेंट पॉइंट है सर, ये बिकॉज सर ने अब जो पॉइंट निकाला है, बिकॉज फर्स्ट टाइम आई एम सीइंग दैट गवर्नमेंट इज relying very heavily on IPs. Sir, please, sir, Anil ji, start करिए इसको।
जी।
Now, see, from my understanding, this fast track insolvency resolution process, I do not see any bullishness on this. Again, another kind of platform which might be started. Presently, this fast track insolvency resolution process, the limits of defaults are, the limits of net worth are very, very low. So we are not able to, in fact, is use this, or even the notification also has not been done. But yes, I believe like how many kind of, we already have CIRP, then we already have PPIRP, then we already have IIRP, then now we will have FIRP. So all this is not really required. What I understand is this PPIRP, they have made substantial changes. One more changes in the PPIRP that they can make, that this moratorium, whether a particular company requires moratorium or not, that power should also be given to COC for taking a decision. And if the DOCOC decides that the restructuring can happen without even invoking moratorium, so they can do that. And otherwise, they can even decide that no, the company needs moratorium for even PPIRP. If the moratorium is given as an option to COC, then they would prefer PPIRP rather than CIRP or even fast track insolvency resolution process. So this is one that we do not know what exactly they will bring when they will redesign this entire FIRP, but we can only say that in case one option is given in PPIRP, that actually will function as FIRP, because even the total time taken in PPIRP is also 120 days, including 30 days for the NCLT to pass an order for approval of the resolution plan. So on this FIRP, I have only this much of observation. Otherwise, what I feel, it is not required. And Nilesh ji and Manoj ji can add, and I only say that the PPIRP can be made more friendly to creditors. So the PPIRP will actually work like FIRP.
सर, मेरी ऑब्जर्वेशन FIRP के अंदर ये है कि इसके अंदर हमारे को एडजुडिकेटिंग अथॉरिटी के पास ओनली 2 बार जाना पड़ेगा। वंस इफ वी हैव टू गो फॉर द मोरेटोरियम, सेकंड इफ व्हेन वी हैव टू पास द रेजिस्ट्रेशन प्लान. If we, some senior IPs like you and others are able to develop an industry whereby CD भी उनकी बात सुने और financial creditor भी उनकी बात सुने, and we bring them to the table and say to them that we can, get you resolved by a appropriate process. So this is something, very good, not only for both the people, because वो भी CIRP के अंदर जाके यही करेंगे। अगर किसी छोटे केसेस के अंदर, जिसके अंदर से 50 करोड़ या कुछ एक लिमिट के साथ साथ केसेस ऐसे हैं जिनको वी एक्टिंग एज एन एडजुडिकेटिंग अथॉरिटी एंड ब्रिंग सीडी और उनको अपने साथ लाके कर लें। सर, इसके अंदर और पीपीआईआरपी के अंदर बहुत बड़ा फर्क है, क्योंकि पीपीआईआरपी के अंदर आपको स्टार्टिंग ही आपकी पहले क्या कहते हैं शेयर होल्डर्स रेजोल्यूशन से होती है, उसके बाद आपको एप्लीकेशन सबमिट करनी पड़ती है क्या कहते हैं एडजुडिकेटिंग अथॉरिटी को, एंड व्हेन दे डू एक्सेप्ट इट ओनली देन यू कैन प्रोसीड। बट इन दिस केस जो ये इन्होंने फास्ट ट्रैक का प्रोसेस दिया है, इसके अंदर नथिंग इज लाइक दैट। Only thing is ki, we as an IP can make CD and financial creditor to sit together, or with this thing we can develop our practice also. And in my opinion, this is something different and very good as far as the all stakeholders of IBC are concerned.
So I think we can move forward, and the final suggestions that we can say, we can note it down, that the financial suggestions, and we can say that presently the PPIRP is also kind of very fast in case section 54J is removed, converting converting PPI-RP into CIRP. That is removed. Liquidation is removed. So the fear of the promoters is also completely removed. And the fear of the creditors is also removed, because the creditors also, instead of doing all this forensic transactions or avoidable transactions, all this has been deleted from pre-packaged information. And the only thing that they have kept is that if there is anything at any time, the COC can terminate the process. That's the most beautiful amendment, that this PPI-RP, just to get rid of all fears of the creditors. So similarly, in the fast track CIRP, let us see what final outcome comes by way of a text, what kind of platform they make. But in case we don't give moratorium to MSME, in case we don't give any kind of protection to the promoters, then the creditors will happily go for PPI-RP, because none of the expenditures are supposed to be bought by the bankers. And in fast track also, in case we are having the same thing, then we are almost duplicating the processes.
सर FIRP का जो कंपैरिजन है OTS के साथ ज्यादा हो रहा था कि when OTS is already there, why should we not go for that? तो इसमें सर what I feel is practically is that कि bankers को जब एक option मिल जाए whereby they are able to get something because of by operation of law instead of because of their whole discussion, they always prefer, because in that case their skin is safe from the CVC or all internal quarters and all this thing. So let's see how this industry develops. We can move to the second. नीलेश जी, आप इस पॉइंट को रख लेना कि we welcome this thing, but इसके अंदर जो लिमिट्स वगैरह हैं वो कैसे होंगी, और that's all.
So I think now moving into the final conclusion, Aman, I think you can decide, Nilesh ji and Vinod ji, because there are two concepts going on in the discussion. One, that this completely PPI-RP, the FIRP is not required. And the other, which is the view, is that this fast track insolvency resolution process would be a good amendment. And these are the two things. And Nilesh ji, Mamta ji, Manoj ji, you can finally decide and you can recommend it to the government. Moving forward, the pre-packaged insolvency, first of all, they are also proposing to expand PPI-RP to other than MSME, because it provides for quicker, cost-effective and value maximization. Now, the framework should be expanded to apply to a broader range of CDs as observed for similar frameworks in other jurisdictions. So they are also trying to see the other jurisdiction. So therefore, this expanding the applicability of pre-packaged insolvency, this pre-commencement stage by proposing RP. So these are the present framework, and what they are proposing now, what they're proposing is that for decision making, for initial decision making, 51% would be required and not 66% for initial decision making. And then even for enabling provisions for IBBI to specify the appropriate threshold, not being less than 51% of the unrelated financial creditor for approving the filing of an application. So these are the decisions where instead of 66%, 51 is taken, then the company would not be liquidated, company would not be converted into CIRP. All this has been withdrawn, and even that certificate or affidavit which was required to be given that no avoidance transactions has actually been done by the company in the last look back period. So that has also been withdrawn. So wherever the COC is not comfortable, COC is observing that the promoters are running the company in a fraudulent manner. The COC is of the opinion that since the resolution plan of somebody else has been approved, though, so we should take over the control. So that takeover of the control also is now prohibited. And this way, I believe the PPI-RP can again bounce back. Only thing is that we can add. The only thing is that we can add that the option to provide the moratorium, that should be with the COC. Your comments, please.
दिलीप जी, आप कुछ कहेंगे?
हाँ जी. I think certain very good suggestions are there. One, reducing this voting threshold and all that. And then at the same time, I think the requirement which is relating to this, which is specified in 54C3C, that they have to, I think, certify that there are no abundance transaction or something. So that requirement is being removed. And at the same time, the provisions relating to conversion of this process into CIRP and then liquidation, I think these provisions are also being removed. So I think more and more people, they will be interested. So I think welcome changes. I think we should support these, except what Anilji has said.
Great.
Then we can, since the time is also short, the subject is very long.
Correct.
Improving the outcomes in real estate cases. And in the real estate cases, I think some further amendments are being made. The status of the allottees in the real estate project as financial creditors, and they would participate into the COC and their divergent interest. So therefore, some of the amendments like allottee under the ownership and possession of the plot apartment. So if there is any allottee who are in ownership and possession of the plot or apartment or building rather than repayment of their advances with suitable haircuts or commencement of the liquidation process, thus there is an inherent tension between the interests of the other Cs like bank who would accept payments even with haircuts or agree to liquidate the CD and interest of the allottees. So to protect the interest of the allottees, there are various experiments like the reverse CIRP and the project-wise resolution was seen. So now the amendments which are proposed in this case is that when an application is filed to initiate CIRP in respect to the CD who is the promoter of the real estate project and the default pertains to one or more real estate project, the adjudicating authority at its discretion shall admit the case but apply the CIRP provisions only with respect to such real estate projects which are having default. So accordingly, such projects shall be recognized as the distinct from the larger entity of the limited purpose for the limited purposes of the resolution. So this is the one and which is coming as a proposal. However, I have seen that there are in fact many kind of shortcomings or practical difficulties in such kind of project-wise CIRP. I can enumerate some things like in case one project is under stress and the other projects are not, then what I say is the practical difficulty is how to allocate liabilities into that defaulted project, how to allocate the common borrowings, how to allocate the common expenses to that project. So how the claim would be received when the money is used on all the projects. So all these are questions and we are not able to find any answers in this public document. So I think this is something which is a kind of difficult, and although it is required, but it has to be followed by a detailed regulations. Unless the regulations would be made and the entire process would be defined, it would be rather more complicated than before. And I will take one more slide and then we'll seek suggestions on the real estate. Now, in section 28 of the code, it will be amended that since the project specific resolution has been considered the ownership and possession of a completed unit of real estate. Now, what is happening is once the CIRP starts and the RP finds that there are completed units, there are completed parts of the project, and RP wants to hand over. However, all the project and specifically those units are mortgaged to the financial creditors. In this case, the financial creditors NOC would not be given by the creditors. So in case the project is ready, one part of the project is ready, one unit is ready, that also will undergo insolvency for 2 years or whatever time it takes. So therefore, it is recommended that the RP will have the power to transfer the ownership and possession of a plot, apartment, or a building. So this is what is the proposal. So the default is somehow is considered to be the project. Defaulted project can be considered as a separate project than from the entire entity. So we just need, because my only apprehension is it is very, very difficult to conduct a process which is restricted to one project. Yes, please.
Yes. So, yeah. So according to me, this proposal is contrary to the basic concept of a company. The concept of company is that it is a separate legal entity. Its different projects are not separate legal entities. The company is a separate legal entity. We can't have more than one CIRP. If a company is having 10 projects, so then for 10 projects, separate 10 CIRPs will be initiated. Suppose today there is a default in one project, then CIRP of this particular one project will be initiated. After 6 months, there is default in the other project, then second project CIRP. So in case of a company, more than one CIRPs, I don't think it is possible, and that is totally against the concept of a company. Company is an artificial person. So an individual, as we know that with respect to an individual, can there be more than one insolvency processes? Answer is no. Reason for the same is that each and every creditor of that individual is having his claim over the assets, each and every asset of that individual. Similarly, in case of a company also, each and every creditor is having a claim. If suppose a claim of with respect to assets of each and every project, we can't create company within a company. So company is one, and there can be only one CIRP. There can't be more than one CIRP, as certain problems have been already enumerated by Anilji, that you can't have, how will you share the common liabilities? How will you share the common assets? So similarly, according to me, it is totally against the concept of company, and I think it's not possible, though already in some cases this type of processes have been, I think, Honorable Supreme Court directed that separate separate process should continue in respect of a particular project, but I don't think it is as per law. I think it is totally contrary to the concept of company and concept of company and the provisions of law. So this is with respect to this particular thing. Then subsequent, the section 28, that if you want to transfer the ownership and possession of a completed unit of a real estate project, you don't need the approval of COC. Reason for the same is that these assets, in the case of a real estate company, the flats, plots, they become part of the inventory. These are not the fixed assets for that particular corporate debtor. These are the assets which form part of inventory, and a resolution professional can deal with them, because he can carry on the business of the CD. He is required to rather carry on the business of the CD. So during the time when he is handling the CIRP, if there is any completed asset, he is entitled to hand over. He is not required to obtain the consent of COC under section 28. So I don't think any such amendment is required, because already it is not. And there is a judgment of Honorable NC LAT in the case of, I think, IP construction, where Honorable NC LAT has said that RP is under an obligation to execute sale deeds in favor of the home buyers who are having units in these completed projects. Okay, so according to me, this proposal, this amendment is not required.
So I can add a couple of things, Nilesh, on this section 28. So you are absolutely right that in the case of hypothecation, when there is a floating charge on the inventory, then the basic nature of hypothecation is that the RP can sell the stocks of a company. But those stocks are basically covered under hypothecation. And even when we look into SARFAESI law, the SARFAESI law is also not applicable to hypothecation, It is only applicable when the physical possession of the inventory is taken. Now, in the case of real estate, now we have to see whether the agreement is hypothecation or the agreement is mortgage. Because see, when we see any unit of flat or any apartment, that has got mostly two components. One is the undivided share in the land, and second is the construction part. Now, undivided share in the land, and that particular land is mortgaged to the lenders, and the construction and receivables are also mortgaged. As far as the receivables are concerned, this is hypothecation and this is a floating charge. And however, as far as this real estate assets like the land and the structures are concerned, these are mortgages. So when it is a mortgage, there is a difference between mortgage and hypothecation. In hypothecation, the definition of hypothecation itself says that the promoters has a right to sell because it's an inventory. The borrowers have a right to float the stock because it's an inventory. However, in real estate cases, the nature of the stock, the nature of the inventory is such that the permission would be required from the committee of creditors because these are mortgaged assets. Presently, this kind of option is not available under Section 28. But in case they will add this option under Section 28 that the committee can decide and committee can permit the RP to sell, I think that will facilitate. I will give another example to you, to the audience, that think of a scenario that a particular company is dealing with the motor vehicles. And when this, those motor vehicles which are unregistered motor vehicles, but once the motor vehicle is registered before the registration authority, then it becomes a motor vehicle. Before that, it remains a stock. However, in the real estate, the land, undivided portion of the land is always mortgaged. It is not hypothecated. So this is the slight change. And so our final, you can take what are the final discussions, or final recommendations. One thing that we agree absolutely is that this project-wise insolvency is a total confusion. It has to be backed up by very, very detailed regulations. Then only it is possible. Otherwise, it is not possible. And it will end up into more litigation rather than solution.
सर इसमें मैं एक दो चीज ऐड करना चाहूंगा. नीलेश जी, जैसे आपने कहा कि ये corporate debtor is a separate legal entity. But we have seen that many a times, corporate will is lifted also, seeing the totality of everything. Here, nothing is being lifted. A concept is being tried to be developed whereby project-wise things will be, done there. What my feeling is that it should not be mandatory. If as per the nature where we were, अनिल जी ने कहा कि expenses को segregate करना बड़ा मुश्किल हो जाएगा. I do agree. आप consolidated return पूरे प्लेट की एक फाइल करते हो, carried forward losses का क्या करोगे? Those things are there because these are developing things.
मनोज जी, इशू डिफरेंट है. इशू ये है, क्या एक इंडिविजुअल के लिए आप 2 इंसॉल्वेंसी या 3 इंसॉल्वेंसी कर सकते हैं?
सर मैं वही कह रहा हूँ.
You are affecting the rights of the creditors of a particular entity by saying कि प्रोजेक्ट वाइज होगा. एक प्रोजेक्ट के अंदर सरप्लस है और दूसरे प्रोजेक्ट्स के अंदर अगर शॉर्टफॉल है तो क्या करेंगे? जिस प्रोजेक्ट में सरप्लस है आप उसका रेजोल्यूशन प्लान अप्रूव कर दोगे विदाउट द कंसेंट ऑफ द अदर प्रोजेक्ट वेयर देयर इज अ शॉर्टफॉल. इज दैट पॉसिबल?
सर इसका सर इसका एक ये भी आंसर है कि वाई जिसकी प्रोजेक्ट कंप्लीट हो गया, जस्ट सक्सेसफुल हो गया, ही शुड सफर बिकॉज ऑफ अदर्स.
नहीं
we can take that call
मनोज जी,
also.
देखिए क्या है, समझ लीजिए. There is suppose 2 projects are there in a company. One is project A, another is project B. A project में though there is a default, but actually there is a surplus inventory is there, and then we are having receivables are also there, but because of cash flow issues the company there is a default. Now we approve a resolution plan for project A where huge surplus is there. Then project B, there is a shortfall. So what will happen is project A will be taken over by some resolution applicant who will be making good amount of money. He will say, okay, I will complete the project. I will hand over the flats in this particular project. I will complete the project and hand over. And then he will be making whatever surplus is there, he will be pocketing that. But what will happen to the other creditors of the other project? तो मेरे अकॉर्डिंग ये इट इज कॉन्ट्रेरी टू द कंसेप्ट ऑफ दिस वन. सेकेंडली अनिल जी, जो हम लोग बात कर रहे थे सेक्शन 28 का, वो हम लोग बात कर रहे थे. देखिए, जहां पे भी अगर बैंक का चार्ज है तो डेफिनेटली आप बिना उसके कंसर्न के नहीं कर सकते. देखिए, मैं आई एम हैंडलिंग सम मैटर वेयर देयर इज नो बैंक, कोई बैंक का क्रेडिट कोई नहीं है, ओनली होम बायर्स आर देयर. There are certain completed project where already sale builder buyer agreement was there. Then उसके बाद ये handover भी हो गया, possession भी handover हो गया. Those people they approached me saying कि भाई मेरे फेवर में आप रजिस्ट्री करो. तो अब रजिस्ट्री करने के लिए जब when I started that process, then others home buyers they came and they said no, don't do it. तो वहां पे according to me, because of this IP construction thing, though I filed one application before Honorable NCLT and which application is still pending. I have requested them to give me direction on this. But I think इस type of situation जहाँ पे कोई mortgage नहीं है, कोई वो नहीं है, तो वहां पे तो power है ही already. और दूसरा ये वो प्रोजेक्ट है जहां ऑलरेडी सेल एग्रीमेंट टू सेल तो हुआ ही हुआ है और पोजेशन भी हो गया है. ये बात है. चलिए नेक्स्ट पॉइंट पे आते हैं.
I think the concept is very clear that if there is a asset, unencumbered asset of the company, that is where we 10% limitation power is required, and that too with the approval of COC during CIRP. And if it is an inventory, then there is nothing required. However, in the case of encumbered asset, then the NOC, because of the original terms and conditions, the NOC is required. So therefore, some kind of amendment is required. I was only saying that the suggestion regarding the project-wise insolvency, we should recommend that the completed project should be excluded. There should be a provision for exclusion of the completed project, and there should be a provision for exclusion of projects where there is no default. Rather, it should be the other way, and the entire company should go into insolvency. All the bank accounts should come under the purview of the RP. However, the completed projects and projects with no default should be excluded from the insolvency. This should be the suggestion rather than project-wise insolvency.
Right.
चलिए, ठीक है सर. Next please.
The approval of multiple resolution plans in respect of the same corporate debtor. This was there in the regulations, and however now it has come in the proposal also. And it is two, three things are very, very important, that if there is one factory, one project, two projects of real estate, or two factories, these can be given to another person. So one resolution plan can be for the cement factory, one can be for the cement factory 2, one can be for overall cement factory, for overall agro businesses. So these kind of resolution plans can be submitted and can be approved. There are two conditions into this, that the entire COC will approve all the resolution plans. There cannot be 2 COC or 3 COC in a particular company, and all the COCs will approve. So if one resolution plan goes first and the second follows, and there has to be at least one resolution plan where the entire company is taken over. So this is a good suggestion, and I am only trying to say that the demerger or hiving of provisions also should be made kind of mandatory, that the NCLT will pass orders for that particular demerger. Although the regulations have not been made, but according to my understanding, that if we have to conduct a process where 2 or 3 resolution plans are made, then it is actually it needs a specialized person who will create separate structures of assets and liabilities for each resolution plan. So which resolution plan will be resolving which part of the debt, and the second resolution plan will be resolving what part of debt. So that is something which is very, very important, for which detailed regulations would be required. As of today, simply by saying that one factory or one real estate project can be separately resolved, I still feel that it needs a lot more regulations regarding the assets and liabilities which will go with one resolution plan, and assets and liabilities which will go with the second resolution plan, and finally with the company. This matter needs a super specialization. Although we understand that we've done in another case, but the only question that I'm trying to say is that unless the regulations are made, and that too detailed regulations, it will be very difficult for this to implement. It will be difficult for the members also to understand and pass the orders, so that the respective liabilities are diminished or waived. Yes, Manojji, what would you like to say on this?
No, sir, nothing more. You know, what you said, I absolutely agree with it. Now, only thing I would like to say is that we should be, feel happy and thankful to the government also, that they are coming out with something innovative. We are telling them there are so many hurdles and so many things are there. Practicability things are maybe some difficult. But what I feel is that when thought process is like this, these practical difficulties, so regulation or otherwise, will be taken care in the days to come. So we at least I feel very happy that government is coming out, or MCA is coming out with such sort of innovations and other things. Maybe because of the outcome of the practical experience they are having through the industry or through other stakeholders. But I really admire and appreciate the government's efforts and thought process on all these counts.
Though already,
yes, please, Naresh, yes, please.
Already some resolution plans have been approved. Where I know one particular matter where I think four manufacturing entities were there, and as per the resolution plan, I think one entity went to one particular company, then two projects went to another company, and then third one project continued with the company which was taken over by some other individual. So this type of provision is possible within the existing law also. And rather, we know that under regulation 37 already there is a provision for demerger. So I think nothing new, but in place of being there in the regulations, I think now it is being incorporated under IBC itself.
Code,
I think that
code.
Yeah.
Giving it proper clothing is always desirable, and we admire for that also.
And there is another thing which is required. That is, as we know that under demerger, you carry forward the benefit of brought forward losses also and depreciation also. But that is possible only when the same set of creditors same set of shareholders are there in the case of the transferee company also. But here, in the case of IBC, most of the cases in the resolution plans, existing equity is wiped out, or existing equity is reduced to nil. So I think there should be some provision under some change in the Income Tax Act, where the carry forward of losses and depreciation should be allowed to the resultant company in case of demerger.
I think we can conclude this part that this is fine, that we are okay with this kind of bringing back to the code,
yes.
And also regulations are required. Now, the next is a very, very important amendment, which is separating the resolution plan approval and the distribution of proceeds approval. So, like if we see the IAs which are filed in a case in a CIRP process, I believe 70-80% IAs are regarding the distribution part of it. So how I can just give you so the IAs would be regarding the delayed submission of the claims, then the non-admission of the claims, then the one person is filing an application that the other person's claim has been wrongly admitted. So this is all basically the distribution issues. And then there will be that security interest has not been confirmed by the RP, that the security interest has not been given to me in the resolution plan. The different stakeholders have been treated differently. Nothing has been offered to the operational creditors. So these are the various kinds of disputes which are pending when a resolution plan is received, or even after the resolution plan is given. These are the disputes which normally come to adjudicating authority. So all these disputes can be kept pending, resolution plan can be approved, let it be implemented, let the assets be upgraded, let the employment be generated, let the GDP be improved. So this is a welcome scenario. And as far as the distribution is concerned, that distribution will take some time. Distribution can happen when all the claims are settled, when all the claims are admitted, when the security interests are admitted, when the dissenting creditors liquidation value is determined. So all this can be decided later on. This will in fact generate some confidence in the market with regard to the resolution applicants. Presently, the resolution applicants are totally working under uncertainty. So therefore, they offer less value. But in case they would have some assurance that the resolution plan will be approved in next 2 months, then they will definitely make lesser cushion for uncertainty and will offer more money to the stakeholders. So this is from my side. Anything can be added into this?
Yeah, sir. We need to develop a resident applicant market also. You know, if we see our Indian standard with international standard, we stand nowhere. With this, definitely our resident applicant market will be developed, and we may reach to some international level also in the days to come.
Welcome move, welcome proposal. I think I welcome this proposal. Yes.
Yeah, I also. Mukesh ji, I also welcome you. We are seeing your video since the beginning. Please share your thought also, so that we also get enlightened instead of it remain confined to we 3 people only. मैं बाकी लोगों से भी request करूंगा, they can on their video. मैंने शुरू में भी कहा था, because तब ऐसा लगता है कि हम आपस में बात कर रहे हैं. नहीं तो अनिल जी हमारे को लेक्चर दे रहे हैं और हम 2 लोग सुन रहे हैं या 3 लोग सुन रहे हैं, तो you know we would like कि अनिल जी should also feel motivated, क्योंकि बहुत सारे लोग ध्यान से सुन रहे हैं. Please.
ध्यान से हम भी सुन रहे हैं सर. Whatever you all 3 of you deliberated upon, these are welcome steps. MC should follow, or IBC should also follow.
Thank you.
मुकेश जी, आपका एक पॉइंटर के साथ बड़ा अच्छा एक्सपीरियंस है. वो हमारे को अगर टाइम मिला तो हम लास्ट में आपसे जरूर सुनना चाहेंगे. सर, he as an IP has a very good, very different sort of experience with Pioneer, where he is an RP. तो वो हम आपसे लास्ट में अगर टाइम मिला तो जरूर सुनेंगे. तो you keep keep ready in your mind what you want to speak.
Still undergoing with various troubles. It is still undergoing.
Sir, Anil ji, yes, please.
So I think the next is the mandating the use of a challenge mechanism, and the challenge mechanism is only for bringing more transparency and for reducing the litigation post approval of the resolution plans. So there are 2 methods that they are now doing. One method is that the separating the distribution proceeds from approval of resolution plan, and the second lot of litigation is when the other RA objects to the process. So therefore, the IBBI is targeting, MCA is targeting on both front, so that the resolution plans are approved within reasonable time. All the litigations regarding claims and the proceeds and the distribution is separated. And now the challenge mechanism, with the challenge mechanism as making it mandatory, I believe the kind of the aggrieved resolution applicants will also have nothing to say, because the challenge mechanism will address all their objections. The kind of transparency would be assured. So this is also a welcome move, that the resolution plans should be approved with a challenge mechanism. I only can suggest one thing, that when we do this challenge mechanism, we should not have every resolution applicant team in the same room. In fact, we can do much better in case we do it on Zoom, where we can keep separate rooms for each resolution applicant, and the one team of the resolution applicant, they should not know what is offered by the other resolution applicant. So in one room, the COC members and the RP's team should be there, and on the other rooms, different rooms, on Zoom, the other people should be there. So that is which can actually be recorded also in video, and that can be seen as a very, very transparent method. There would not be any possibility of a collision and a kind of cartelization. So this is a good mechanism. I think the practical experience is that we should not get them sit in one room, because that is not working well. Yes, please.
Correct. Totally agree with that. But I think one important amendment, proposed amendment, I think we have not made the discussion on, and this is under para 9.6. Para 9.6, which was relating to one was this separation of resolution plan and the distribution of proceeds. So relating to distribution of proceeds, as there is a suggestion that based on the liquidation value, section 53 distribution.
We are coming to that. We 9.6 and 13.1. These are two things that we have to collectively address. Definitely. Because yes, this 13.1 and 9.6 has got a separate application, and we have some suggestions on this. And I think after this, that will come, because that is the reason that we wanted to deal both together. Just wait for a minute. I think we'll handle that.
Okay. At that point of time, we'll discuss.
So,
right.
The next is the monitoring of the implementation of the resolution plan. So presently, there is not any word in the code how the monitoring committee would get powers and what kind of powers would be given to the monitoring committee. So there is a proposed now framework, and this framework would actually be a little bit of enhanced with some kind of duties and some kind of responsibilities that would be given to the monitoring agency. Any comment on this? Or I think from me it is a welcome suggestion, but I only will suggest that the powers and the scope of the monitoring committee should be completely addressed in the amendment. Is it okay, Nileshji?
I think, yeah, it's okay. Yes, we can.
No, the other is the providing an opportunity to cure the defects in the resolution plan rather than liquidating a company. That's what the responsibility of the adjudicating authority, that they can send the resolution back to the committee of creditors for curing the defect. In fact, practically it is happening, but in somehow it is not really. So it was not in the code. So they are bringing it in the code that in case of any defect, they can cure the defect. And so before we actually move on to the main impact, like the secured creditors definition and the allocation and the waterfall, we have another issue, which is reinstating CIRP. And this is what is proposed to be reinstating CIRP after even the liquidation order is passed. Now, what I believe that this there were criticism on two things. One, that the liquidation, the sale of the company and the sale of the corporate debtor in a liquidation process as a going concern, because everyone gave a feedback that this was a half law. The regulations were not fully supported, and the powers of the adjudicating authority is unseen in the code. So this, either the law should be complete or it should be withdrawn. So it was also recommended that there are many companies which are seen revivable during liquidation processes. So therefore, this the COC can decide reinstating the CIRP once this particular section would become law. This proposal will become law. I believe all the regulations regarding the liquidation as a going concern would be removed from the regulations. So there will not be any process called sale of company in the process of in liquidation as a going concern, and also the section 230. Also, section 230 may not be, and that also may be withdrawn. So there will be only one thing, and in case the committee decides that the company can be revived, the committee can actually bring it back to the CIRP. That's the only possibility, I think. So reinstating CIRP is like this. So this is something which any comments on this reinstating, because the time is also very short, so we are also trying to rush away.
So then in that case, I think my opinion is, or my view is, that then CIRP process, this process will become unending, because the objective of this law is that within a time-bound manner, you have to take a decision as to resolution. And if resolution fails, the next step is liquidation. So what we are doing is that after when liquidation is started, then again we can come back to CARP, then liquidation again, and then coming back to CARP. How many times this will happen? So I think it is totally against the principles of this IBC. But still, let's see.
So, still, we will recommend something which is like this, that this seems okay, but then it has to be very, very cautiously used provisions. This is what I think. Cautiously approved. I think we can now jump on to paragraph 9.6 and 13.1. There are other things which can be skipped, otherwise the time will actually, we will not be able to get appropriate time. So the first is the improving recoveries for operational creditors in liquidation, and the present framework is that there have been several judicial opinions in favor of the granting equitable distribution to OCs, and the recoveries made by the OCs under liquidation are seemingly inadequate. This is the present framework, and the proposed network is all the unsecured creditor. So this one is proposed in paragraph 13.1, that in liquidation, all unsecured creditors, means financial creditors, operational creditors, and any government or other authorities other than the workmen and employees shall be treated equally for distribution under section 53. Now, this means, according to the first reading of this 13.1, it shows that in liquidation, this kind of arrangement will work, that the first line of the credit would be all the secured creditors. And if all the secured creditors are settled, then whatever is the balance, that will be distributed between the unsecured financial creditors, government authorities, and operational creditors. However, the rights of workmen and employees would not be tampered with. They would be remaining at the same as the section 53 presently proposed. So this is what is the proposal in paragraph number 13.1, whereas in paragraph 9.6, which talks about resolution, it is says how the second thing which is said in this 13.1 is the order of priority for secured creditors, workmen and employees shall be retained as stipulated under section 53. So there is a confusion. Again, when we talk about in section 53, there is nothing that we talk about as a priority of order of priority. But they are only talking about the order of priority between the secured creditors and the workmen and the employees that will be retained. So there is no sentence mentioned which talks about the first charge, second charge, and the subservient charge. Also, there is no sentence mentioned that the distribution would be based on the value of the security interest of each creditor. These are the two things missing in distribution amendment. We haven't seen, because this is a disputed thing as of now, whether the priority of the first charge, second charge would be retained or respected by the liquidator. Secondly, one person has a claim of 1,000 crore and the value of the current assets and the security interest is only 5 crores. So would he be entitled to 5 crore, or he would be entitled to a proportionate amount on the entire assets of the company? So these are the two clarifications that we still need, whether the first charge, second charge, subservient charge would be respected by the liquidator, whether the distribution will be based on the value of the security interest of each one, whatever is realized from their asset. So this is one immediate, everyone should write. This is a suggestion. Now, this is something which is the clarity in the treatment of security interest created by statute. This is for section 3, section 30, security interest and all that. That's very, very clear. But then I would actually move on to the on one step further. I think I only have to read it from that part, that in 9.6, I have read it like this, that in a resolution plan, the proceeds would be distributed. The proceeds would be distributed amongst the stakeholders in a manner that first of all, the liquidation value of each secured creditor will be distributed to them. The liquidation value will be based on the valuation of registered valuer. In that case, what I'm trying to say, the section 9.6 says the liquidation value of each creditor would be distributed, and whatever remaining. So now we have seen in liquidation in section 13.1 how the distribution is proposed, that all the secured creditors will be settled. Then whatever is balance, that will be divided between the unsecured financial creditor, operational creditor, and government liabilities. So there are 3 shares into the balance amount. Now, in case of the resolution plan, it is said that first the liquidation value of each creditor would be distributed. Then the remaining amount will be distributed to 4 categories. 4 categories of the creditors. One is the remaining amount of the secured creditor, then unsecured financial creditor, then operational creditor, and the government liabilities. So these are the 2 different paragraphs in these proposals. One is applicable in resolution plan and one is applicable in liquidation process, 9.6 and 13.1. Although we are okay with this, however, we need this clarification that in liquidation process, whether the priority of charges has to be respected or not, whether the value of the security interest while distributing has to be respected or not, which the matter is pending before the Supreme Court, and the law needs very, very urgent the intent of the legislature. So these are the 2 things, and then we will move on to other small things in case we can discuss this 9.6 and 13.1. Yes, Nilesh.
Yes.
Sir, इसमें financial creditors को और OCs को same level पे लाना, I have my some, and government dues also bringing the same level. Nilesh, what are your comments on it? I have a reservation for that.
Okay. First of all, 9.6. अच्छा,
मैंने सबको म्यूट कर दिया, अब अनम्यूट हो जाइए. नीलेश जी, अनम्यूट.
Yes.
Yes. Now,
Correct. First of all, 9.6. So see what 9.6 is saying is that distributes the liquidation value as per section 53 in a resolution plan. So what we should do is that distribute the liquidation proceeds, distribute the liquidation value as per section 53, and after that whatever is left, that should be distributed between all proportionately. So what we are going to do is that this decision as to how much should be the entitlement of a party, of a secured creditor or workers or unsecured creditor, that will be decided by 2 valuers. And valuation is only an opinion. Valuation is only an opinion. If you go to 2, 3, 4 valuers, all of them, they will be giving different valuations. So it is only an opinion. And a secured creditor's right over the asset cannot be made dependent on this valuation. His charge is over the actual recovery. So if a resolution plan is offering 100 crore of rupees, and then you say that liquidation value is only 60, and secured creditors entitlement should be based on 60, I think it is totally wrong. It is totally wrong. You can't say that the secured creditor right will be decided by this valuer. No. His right will be decided by the market, whatever is being offered. So if his charge is, if his dues are, secured creditors dues are, suppose 150 crore, and the resolution applicant is offering 100 crore, then major share should go to the secured creditor. His right should not be decided based on a valuation. So I'm totally against this manner of distribution, proposed manner of distribution. Now let's come back to the 13.1. 13.1 says, it says that the in case of liquidation, first CIRP cost and liquidation cost. After that, secured creditors and workmen dues for the last 24 months. And third one is employees dues. They say that after that, all of them, they should be at par, which is totally contrary to we know that for unsecured financial creditor, priority has been given. And what is the reason for the same? Reason for the same is that we wanted to improve our market, or we wanted to promote our market of unsecured bonds for that purpose. So unsecured financial creditors, they were intentionally, they were given a better treatment than the others. So now are we willing to go against that particular policy? I think that was for the purpose of a development of this market, and still there is a need, because our bankers, they are dealing with medium-term funds. They can't give money for the projects which are long-term in nature, 25 years, 30 years project. So for that purpose, there is a need for development of bond market. And for that purpose, we must give them priority over others. So this was one. Second is, see what will happen to our home buyers. Home buyers are also unsecured financial creditor. You are putting them at par with the statutory creditors and unsecured creditors. So they will not get anything. So I think it is also totally contrary to what has been proposed at the time when this law was made. And I don't think that there is any logic on this. Though we want that something should be given to the unsecured creditor, but by making this change, I don't think they will be getting anything, except in those cases unnecessary complications will be there where there are no secured creditors. Like in the case of home buyers. Home buyers, now they are having priority because they are unsecured financial creditor. Okay, so I'm not in favor of this particular creating of this confusion and all. I think we should oppose this. Then Anilji was saying that this particular issue, that first charge holder, second charge holder, or etc. So that thing should be clarified. Though presently under section 52, we know that the secured creditors, they are having that option to decide either to sell the assets themselves or to relinquish the charge. If they relinquish the charge, then they are having the priority. So if they are not relinquish the charge, then in that case, if they are having first charge, so they will not relinquish. Why should they relinquish? Relinquishment means they are throwing away their security in the common pool, where it will be distributed as per section 53. So if there is a security, you are having first charge and you know that you can get a better realization, then why should you share it with second charge holder or with residual charge holders? So I think because relinquishment is there, I don't know whether any clarification is required. However, in case of because the present arrangement does not give any incentive to the secured creditor to allow the liquidator to sell the assets. So if I think this type of change in law is there, that yes, if you are having first charge, then you will be given a better treatment than the second charge holder, I think that will improve this liquidation process, as secured creditor in that case will be allowing the liquidator to sell. So these are my comments.
Sir, इसमें अनिल जी आप इस बात को conclude कर देना. Feeling in the government is that कि OCs are always helpless and COC is not taking care for them. तो इसका that is why they thought of clubbing all this thing there. और जो government और dues का है, I think ये rainbow की effect है या क्या और effect है. That is why they have clubbed with it. But I feel that is a skewed thinking on the part of the government to club all these things. What I feel is that if we are feeling that OC is not getting a fair treatment under IBC, we can propose like this, that out of say if as Naliachi was saying, that if some 100 crore are coming out to be there, let 10% of it, 20% of it be reserved for these people who are not part of the COC, like OC, and how that will be distributed. Then again, that can be distributed as per the waterfall mechanism under section 53. तो मेरी तरफ से एक ये सजेशन है, just for the sake of taking care for OCs, और as far as FCs is concerned, I absolutely go with Nilesh ji कि FCs की जो मार्केट अगर हमने डेवलप करनी है तो we need to give them the priority in its seat against any in any CRP or liquidation. Anil ji, please आप conclude करिए. Sir, mute है आप.
What we are trying to say that this clarity is required so that we reduce the litigation. Secondly, as far as this valuation is concerned, the process of valuation is going to be a very, very transparent process now as against the past, because there are other amendments, like one, that the valuer will have to interact with the committee of creditors. Then the second amendment is that the valuation of assets would be the part of the information memorandum. And the third amendment would be that, first of all, the liquidation value of each creditor would be distributed and the balance would be distributed to others. I had certainly said that there is a difference between an unsecured financial creditor and the operational creditor. Now, in case we understand the risk of an unsecured financial creditor, there may be unsecured debentures, there may be unsecured loans, and there may be various other loans which has been paid by a person out of tax paid money. Now, there is no restriction of any loan which you can take. However, when we talk about the operational creditor, what is the risk of an operational creditor? That is one supply cycle. The risk of an operational creditor is restricted to one supply cycle, because today we have seen in the budget that there is an amendment that in case of an agreement between an MSME, 45 days is the maximum. However, the kind of protection has been given to the small and micro MSME, that in case the payment is not made to them, that would never be allowed under section 43B. No, I'm repeating never, because see, the proviso to section 43B, there is an exception to this particular clause H, which has been added by this finance bill 2023. So that means that in case I am buying from a micro or a small enterprise, and I'm not making payment to them within 15 days or 45 days, depending on the two circumstances, then I will never get that deduction from the income tax department ever. Even if I pay on later on, even if I pay later on, even if I pay before the filing of the return of income, but that particular amendment is something which is a very big demand of the MSME has been met by this simple one amendment. And now, if the operational creditors are still saying, that they are suffering, that means they are voluntarily supplying to those companies which are not making payment to their earlier bills. If an operational creditor decides to continue supply to a company for 1 year or 2 years without taking any payment, that is the kind of charitable activities that he is doing it. Otherwise, he should stop the supply when he is not getting the payment. The default has already occurred. Have you seen any bank who actually keeps on giving the loan when the default has already occurred? So the operational creditors, their risk is much restricted. Their risk is much limited. It is only restricted to one supply cycle. So the unsecured financial creditors' priority should not be changed. That's what is our suggestion.
Correct.
Sir, नीलेश जी एक मिनट, अब आपने ये ऑपरेशनल क्रेडिटर्स की बात करी एंड सेट कि उनका एक साइकिल का रिस्क होता है. अनिल जी, आई जस्ट रिमाइंड यू आवर सीए प्रैक्टिस डेज. हमारा तो एक साइकिल तो लग जाता था पहले काम करने में, और उसके बाद एक साइकिल लग जाता था पैसे रिकवर करने में, एंड दैट सिचुएशन इज स्टिल देयर. And
today it is all a good day for all the professionals, because all the professionals are micro and small enterprises.
Agree.
Including insolvency professionals. Everyone is protected in this amendment today. And although when we claim it from a dead corporate debtor, they are not bothered whether they get disallowances under Section 43B or not. But for a normal practicing chartered accountant or a practicing advocate or a practicing company secretary, I believe they are all service providers. They are all MSME. They should get immediately registered themselves as MSME, and then they should claim.
Agree, sir. इसकी भी हमने एक प्लानिंग करी है with our corporate clients, so हम आपसे बाद में डिस्कस कर लेंगे, because it was affecting their working capital a lot. 15 दिन का 45 days का था. We planned for that also the moment this came in the budget. But it is, sir, मेरा कहने का मतलब है कि OC का हम ये सोचे कि वो उसका एक साइकिल तक रहेगा या वैसे रहेगा. OC is heavily dependent generally on the CD, especially for certain types of trade, where जहाँ पे different types of trade के ऊपर है. What I feel, despite your all this saying, I still feel that OC is still vulnerable. Some sort of protection he be given, which he is not getting fair treatment from the COC. That is all. That's all my say. But I fully endorse and agree with you कि FC और OC को तो कभी क्लब करना ही नहीं. और सर गवर्नमेंट वालों को क्यों ला दिया इसके बीच में, जबकि प्रेम्बल ही हमारे ये IBC का ये था कि गवर्नमेंट विल हैव द लास्ट प्रायोरिटी. अगर वाइफर वगैरह के केसेस फेल हुए तो इसी करके मेनली फेयर हुए कि बिकॉज they thought of कि everything will go to the government. Why should we revive the company? Nilesh ji, you are more experienced. You have dealt so many cases. Please have your comments.
हाँ जी, तो सबसे पहले मनोज जी जो हम लोग बात कर रहे हैं कि ऑपरेशनल क्रेडिटर्स they are not getting a good treatment under resolution plans. I don't agree with that. Reason for the same is that secured creditors, they are giving the money against the security. Okay, and you are unsecured creditor. When you are dealing with the corporate debtor, you know that you are taking a risk. So you should not make supplies if you have not seen the balance sheet. Though it is another thing that our this particular sector, MSME sector and others, operational creditors, I think they are not, all of them are not competent enough to analyze the balance sheet and to see whether they should make supplies to these entities or not. I think government should do some things to enable them to take this type of decisions. But at the same time, you see your status is of an unsecured creditor. You are a supplier, unsecured supplier. अगर आप ये करोगे कि आप secured creditors के शेयर में से कुछ कट करके उनको दोगे, तो what will happen is that it will impede, it will restrict the credit in the market. That will be how that will be, because one is that if a secured creditor, he knows that out of the value of the security, 10% is going to go to the unsecured creditor. So they will insist for higher value of security. तो अगर आज मेरे को लोन देना है 5 करोड़ का, फॉर एग्जांपल, सो आई से कि ठीक है आप मुझे 10 करोड़ का सिक्योरिटी दे दो. अगर मुझे ये पता है कि उसमें से 10% अनसिक्योर्ड क्रेडिटर को जाएगा, तो मैं उसको भी कवर करके आई विल इंसिस्ट फॉर सिक्योरिटी ऑफ एन अमाउंट ऑफ 12.5 करोड़. So which will restrict the credit in the market. Second is additional risk premium. अगर मुझे पता है कि मैंने सिक्योरिटी देने के बावजूद भी मेरी सिक्योरिटी उसके साथ शेयर हो रही है, मैं इंटरेस्ट कॉस्ट, मेरा रिस्क बढ़ रहा है, मैं इंटरेस्ट कॉस्ट बढ़ा दूंगा. तो आई थिंक दीज थिंग्स विल बी हैविंग इम्प्लीकेशंस. हमारी जो क्रेडिट अवेलेबिलिटी है इन द मार्केट, दैट विल बी अफेक्टेड बिकॉज ऑफ दैट. आई थिंक वी शुड नॉट मेक एनी चेंज इन दिस, एक्सेप्ट दैट ये कर सकते हैं कि सम स्मॉल पोर्शन, बट दैट इज नॉट गोइंग टू हेल्प देम. अगर मैं ये भी कर दूं कि उनके ड्यूज का स्मॉल परसेंटेज विल बी गिवन टू देम एंड दैट विल बी आउट ऑफ शेयर ऑफ सिक्योर्ड क्रेडिटर्स, दैट इज आल्सो नॉट गोइंग टू हेल्प देम मच. अगर उनके ड्यूज है 10 करोड़, उनमें से मैंने 10 लाख 20 लाख उनको दे भी दिया, तो क्या उनका भला होने लगा? कुछ भला नहीं होने वाला. तो दिस इज वन. सेकेंड, आई थिंक आप मुझसे जानना चाह रहे थे उसके बारे में. I think Manoj ji, you asked me about something, huh?
BIFR में आपका एक्सपीरियंस है.
अच्छा, स्टैट्यूटरी क्रेडिटर.
ये कि भी अगर उसमें स्टैट्यूटरी लायबिलिटीज को कुछ ज्यादा वेटेज देते हैं, तो क्या उसका इम्पैक्ट हुआ था ड्यूरिंग दैट रिजीम ऑफ BIFR?
जी, देखिए ये जो प्रपोज्ड, ये जो IBC में ये जो चेंज आया है, एंड इट इज देयर इन द preamble also, that the priority of statutory creditors has been reduced. That is because of our experience with BFR. In most of the BFR approved resolution plans, the problem was that the statutory creditors, they were insisting of a better treatment. And in most of the cases of insolvency or the cases which were there in BFR, what is happening is that companies are lying close for for some period of time, and these authorities during the closure period also they pass assessment order, creating huge liabilities, though there is no actual sale. And when, because operations are lying close, there is no appeal also, which is made by the corporate debtor. So huge liabilities are created. Their interest rate is also very high. So it becomes very high statutory liability. And if you provide in the law that they will be given any priority, I don't think any resolution plan can be approved. So it was a conscious decision taken by the lawmakers at the time when this IBC was framed, that these statutory creditors, these are government dues. And in a particular case of a company, they constitute very small percentage of the total government dues. So if in a resolution plan, if a company can be revived by waiver of this, so then it should be done, because government interests are not getting affected because of all this. But if that company is revived because of this waiver, so the company will start paying the taxes. If operations are there, then GST, income tax, and a number of other dues, it will start paying. So that was the reason that this change was brought in this particular law. So this should not
we have the consensus that it should be not accepted. This amendment should be opposed. आप इसको writing में सर कर लेना. Already हमारे पास hardly 20 मिनट रह गए हैं. तो सर को please हम आगे move करने का request करते हैं. Sir, please move forward. Then we have a question answer session also.
I think this is very important, that the state tax officers versus Rainbow Paper Limited, the impact of this judgment of Honorable Supreme Court is also likely to be diluted with the this kind of amendment. Because see, it was also being thought in the market that the Supreme Court has mandated that if there is anything which is mentioned in the law, so the security interest would be created automatically on behalf of the state tax officer for any VAT issue, for any GST issue, for any service tax issue, for any custom issue. So this is the kind of market understanding, and in fact we have been getting orders from NCLT, which is based on the Rainbow Paper Limited. Now the proposal which is before
sir, इसमें एक मिनट के लिए आपको रोकूंगा. Although it is not related with it, लेकिन हम लोगों की गाइडेंस के लिए आप बता दीजिए, अगर इस तरह का कोई नोटिस आ रहा है जो NCLT ऑर्डर दे रही है, considering this proposed amendment, what call as an IP we should take, because a lot of IPs are being affected with it.
So see, like we are getting some kind of calls from the state tax officers and from the income tax department that you were RP in such case and our claim was there and you have not admitted that. So we are saying that you please write us the email and we will reply it. So when we are replying it, so they actually have only one option to go NCLT, and NCLT, after the clarification from the in the review petition, now may not try to disturb the resolution plans approved earlier or the dissolution proceeds distributed earlier. They may not go again that way. But I don't think we should take any such action, but then we actually have to respectfully tell them that you can submit your claim to NCLT, because I cannot admit your claim in liquidation because it's delayed. I cannot admit your claim in the CIRP because it's delayed. As far as this automatic claim is concerned, you have to file an application to NCLT. That's what the reply that we should give. See, now the proposal is that all the debt owed to central government and state government, irrespective of whether they are secured creditors pursuant to a security interest created by a mere operation of statute, shall be treated equally with other unsecured creditors. So this is what is the proposed amendment, because see, now we have seen that the waterfall mechanism is also proposed to be changed. So therefore, this is the language. Further, only where the security interest is created pursuant to a transaction of the central government and the state government with the corporate debtor, the government in question will continue to be treated as a secured creditor in the order of priority. Now, the automatic creation of security interest is diluted. That is the law will be made that automatic creation of security interest would not be there. Secondly, if there is any security interest that has to be done through a transaction, and when I see the definition of a transaction, it says that the transaction means when there is an agreement in writing and that agreement is executed by both the parties. So it is not like kind of a kind of unilateral action by the state authorities or any taxation department. It has to be a bilateral action. So there is a difference between unilateral and bilateral action. So the unilateral is not accepted, bilateral is accepted as a security interest. So I will give you the couple of instances, like maybe the government department, electricity department, when they give connection to you, then they also get an agreement signed that in case the electricity dues are not paid, then we will have lien on the assets of this company, on which or assets on which the electric connection is given. So we have treated them as secured operational creditors and we have given them their dues. Similarly, some of the State Industrial Development Corporation, they also have an agreement which is executed by the corporate debtors that in case of any of their dues are payable, they will have a lien on this piece of land. So we have also considered them, treated them as secured operational creditors and have allocated them proportionate to the secured creditors. So that's what is now also it is proposed, but this is the real law, that if there is already a transaction, it is irrespective whether the transaction is with a government authority or not, but that transaction means that there is a security interest that should be respected.
Yes, sir. इसमें एक छोटा सा और enlighten कर दीजिए, because although it is not absolutely related with it, it is with reference to PF dues. PF dues के against भी बहुत सारी दिक्कत आ रही हैं, especially when there is an interpretation of section 36 subsection 4 is subsection A and I think subsection 3, whereby PF dues are being demanded by the authorities a lot. So, sir, please, इस पे भी थोड़ा सा lighten कर दीजिए, so that we can have a call on that also.
See, I believe the kind of judgments that we are now getting in the case of Jet Airways from the Supreme Court, from the NCLAT, I think the intent of the judiciary is very clear that we have no right to eat away. We have no right to eat away the gratuity of employees who have worked for 30 years in a company, and that particular saving was their lifeline. So we cannot eat away because of the insolvency of that company. Secondly, the provident fund. The provident fund is something when the salary is disbursed, some amount is deducted and the other part is paid by the employer. Now that is also something that we cannot eat away. Any employee who is registered under PF and he's paid the salary and he's got deducted some, that is a kind of compulsory saving by an employee, which is basically kept for the education, for the weddings, for the illness of the family members. Any insolvency of a company cannot eat away these two things. However, the provident fund is restricted to that provident fund which is paid against the disbursed salaries. If there is no salary disbursement, the provident fund is not payable, it is not due. So the provident fund and the gratuity, I am now advising everyone that you should actually admit the gratuity claims in full as on the commencement of CIRP, as on the commencement of liquidation. The gratuity should be paid in full. Secondly, the provident fund dues, to the extent of the amount which is due to the employees, that should be paid in full. However, the interest which will go to the provident fund organization, EPFO, or the damages which will go to EPFO, that you can consider as statutory liabilities and consider them as unsecured. So in case you will do that, and I think no challenge would be acceptable against your resolution plan or against your distribution. But like eating away the gratuity or the provident fund, you will never get a favorable judgment on this. It is better that we should all start doing it.
So
okay,
what they are saying is eat away the entire salary or eat away the entire wages. But if you have deducted 10%, if you have paid and you have then that 10% share you have to pay. But
no, I think Nileshji, I tell you one thing. Like if you see the wages, the wages only preference is only 24 months wages.
Correct.
If there is a worker who is
continuously last many years,
who is continuously paying, who is continuously working for a company without getting any wages, that is his job. That the whatever 24-month wages that is the only thing that has been assessed as patience of a human being, that he will still work with the company. What I am talking about is that the employee is working, he is getting his salary, but his PF is not being deposited for the last 7 years, or his gratuity insurance is not being taken by the company for the last 30 years, 35 years. I'm talking about these two things. As far as the,
totally agree with you.
as far as the salary and wages are concerned, that is all the patience of a human. If you are not getting salary, you can maximum work for 12 months as a salaried person. That is the reason that the 12-month salary is paid as a little preference. And as a workman, you can only work for 24 months because of some unskilled factors. Beyond this, nobody will work without getting salary. That's a human tolerance. That's a human tolerance.
Sir, in case of gratuity, sir, a question. Although I'm absolutely clear on it, but still I would like my IP friends to understand this also. In case of gratuity, even if there is no fund created, even then you should pay to them?
Yes. I think the message is very clear that we cannot eat away somebody's 35 years of income or the kind of saving that we have no right to eat away. Neither the secured creditor, nor the government, nor the unsecured creditor, no one should eat away that part of the humans.
Okay. Nilesh, please carry on. You are adding something?
Acha, no, what I was saying was that under SICA also, so if you have deducted something like PF contribution, so two things. One, you have deducted 10% from the wages of the worker. So for that amount, you were treated as a trustee. So that was not treated as a relationship of debtor and creditor. So there was no protection against that under SICA. So that was treated, you were a trustee and you should have deposited that. Now, so similarly here also, if you have deducted some money from the workers' wages, I think that should be paid in priority to the other debts. I think that is based on this view, this judgment has been, I think, given. Yeah.
I think we also have to move forward. And
please move forward.
We very quickly, we will just run through that the valuation estimate is supposed to be disclosed in the IM now. I think this is also a kind of bringing some transparency in the process. Although we say that the valuation, in case it is disclosed, the resolution plans will only come, which is
at that value only.
Yeah, treating it as a base price.
But I still feel that in case the valuation is disclosed in IM, in case the valuation is disclosed to the COC, in case the valuation valuer is also interacting with the COC, then the quality of the valuation will improve. The quality of asset tracing will improve.
Anilji, in all the cases, we have seen that valuation is for such and such for a particular amount, and actual proposal is totally different. So valuation is only an estimate. An estimate of what? As to at what price you will be able to sell it. And in all the cases, it is proved that yes, valuation is different. Valuation is the estimate which was made was totally wrong. In all the cases, it is being proved. So I think we should not give too much of importance to the valuation. Valuation is only an opinion, not more than that. Ultimately, rights have to be decided based on actually what is being offered by the market. And I think if this valuation is disclosed in the information memorandum, I think it is not advisable. I don't think that it will give some transparency or anything, because the resolution applicant, he makes his own estimation of each and every asset, and based on the same, he gives his resolution plan. He does not give his resolution plan based on the valuation made by the valuer appointed by resolution professional. I don't think so. So what will happen is that in all the cases, if you have given a valuation, that all the resolution plan, that will be around that figure only. So I don't agree with this, that we should disclose this, but we are having
there is another factor in my mind, and that factor is that if the details of the assets and the valuation is given in the IM, then the due diligence time by the PRAs would be reduced. There may be more people who would be interested in the assets or in the plan. The present uncertainty about the value, uncertainty about the Because see, in case we see the overall picture, what is proposed. Number one, the creditors will get equal to their valuation. Therefore, the valuer is important. The resolution plan will also have the valuation. So therefore, the valuation is important. So the valuation, the quality of the valuation is going to be a very, very improved process now. And therefore, there will be a lot of pressure on the resolution professional also to provide information to the valuer. In a couple of meetings where Ankit was presented, the committee of creditors asked Ankit that how can you value the receivables of 200 crores as zero? So Ankit said, as a valuer, if I get no information, how can I value it? I do not have books of account. I do not have the copy of account. I do not have the third party confirmation. I do not have the detailed understanding how this particular amount is due. So then after that, the COC, they were asking questions from the RP that why you could not get this information. What was the reason that this information was not given to the valuer? So therefore, what I'm trying to say, the difference that you are finding nowadays between the actual resolution plan value and the liquidation value is only because of the incorrect valuations, which are likely to be improved now because of the transparency in the valuation process, because this is not a confidential issue now. So therefore, if the valuation quality improves, if the valuation is disclosed to PRAs, if the due diligence period for the PRAs is reduced, if they are given some ready information about the assets and the businesses of the company, then I believe the overall resolution plan will have maximization of the value. This is my belief.
But Anil, resolution resolution applicant, वो अपना वैल्यूएशन कराएगा ही. इट इज नॉट कि वो मेरे वैल्यूएशन के बेसिस पे अपना प्लान देगा, वो अपना एस्टिमेशन करेगा ही.
Nilesh ji, we agree with you also, but Anil ji has a weight in saying this thing that if it is disclosed, it will be good. Now time sir बड़ा कम है, तो हम ये इस proposal को acceptance के angle से share करते हैं, in my opinion.
We will discuss about that. Yes.
Okay, sir. Okay. We shall discuss one to one.
I think this is regarding the various ag licenses, like all this will continue. Section 14 applicability. I think there are many judgments also, and that is all acceptable. Section 14 will have all these permits, licenses, services, registrations, quota. Some of the operational creditors, they would have no right to discontinue the service. This is a welcome change, although this was also there in various judgments earlier also. Certain categories of the operational creditors to honor the agreement with the corporate debtor. This is what, again, I have the same section 14 thing. Protection of the resolution applicant post-implementation of the resolution plan concerning civil liabilities. So the clean slate is already there, and it is only kind of fortifying that concept that the resolution applicant, successful resolution, will get a clean slate. He will get protection from the civil liabilities and also criminal liabilities. That is something which is, again, much respected and much wanted, this thing. Now, the clarity on the computation of voting share and treatment of absenteeism. Now, the voting share means present framework is this much. And now, in some cases, in some COC cases that we have seen, and especially some cases where only operational creditors are making the COC and larger parties with the government authorities, then they are not cooperating with the process. 66% at sometimes is not possible. So they have given a kind of option that in such cases, you can actually see anyone who is voting. And then out of the voting, if 51%, out of the voting, if 66% is there, however, overall 51% is required. Out of 100%, 51% is required. And out of those who are voting, 66% is required. That's a new kind of definition which they have given for facilitating some of the cases where the resolutions are not approved. Interim finance providers, they also will get some kind of seat in the COC without voting power, so that they can understand the valuations, they can understand the process, and they can only see whether their interim finance is protected or not. It's again a welcome proposition. and the administrator by the central government. Now, in some companies, the government say, so some see like under section 241 subsection 2 of the Companies Act, there is already a power with the NCLT to appoint an administrator where some kind of mismanagement operations are taking place. In case there are warring promoters, then again the under section 241, the administrators are appointed. See, however, in the proposal, the government is saying that in some cases where some public interest is involved and the IBC has to go through, then instead of insolvency professional, the government can appoint an administrator, and that administrator will run the process, the COC will supervise it, and the administrator will do the duties under IBC. So this is we are not really understanding. We should not accept this kind of change where it is seen that the government is showing some kind of trust deficit in the insolvency professionals. Why the administrator will do a better job as against an insolvency professional who is experienced and much knowledgeable about the law? Why an administrator will not will be doing a better job as against the insolvency professionals? So we think that this is another way that the government wants to give some kind of posts to their own loved people for larger companies, as they have done in Unitech. So for the larger companies where much public, like maybe some companies where a lot of public deposits are there, some companies where a lot of home buyers are there, so they may appoint administrator as they have done in Unitech. So we should not agree as an insolvency professional. Even otherwise, this will only give government to give some good positions to some of the retired bureaucrats or some of the retired bankers. This is my view. I couldn't see any other objective in this.
Or we can say alternatively that appointed administrator should be a qualified insolvency professional. Can you suggest it that way? Alternatively,
certainly, we can recommend this.
Because the government has some other objectives also, whereby they say that these are the companies where we don't want COC to have any say in the proceedings of the company.
Should be appointed as administrators. I think
we can say is that administrator should be appointed, IP should be appointed as administrator. That we can suggest.
Correct.
I think that's a better suggestion.
Sir, Anilji, please.
Yes.
So there is some kind of power that the government has taken it in its own hand, like the government can exempt any class or classes of the corporate entities from the provisions of this code. That means that they may see at any point of time that there's some real estate sector or some state is going through a bad period. There is some state which is impacted by some natural calamities. So therefore, some class of corporate debtors, or maybe at times the government thinks that this thermal power companies are not doing well. So all the companies will go to insolvency. So they can protect these kind of companies so that the overall economy of the country is not impacted. We don't see any negativity in this amendment. We can think that the government should protect those companies which are important for the country, which are important for the humans. However, going through a bad phase, we should protect those companies. I don't see any negativity into this. Individual insolvency. In individual insolvency, section 96 moratorium was being misused. The government has plugged that, and also the non-submission of repayment plan. Already it was written that no meeting of the committee of the creditor is required. No meeting of the creditor is required, but now they have made it mandatory. A meeting of the creditor would be required. So these are the two lacunas that has been plugged. So the like addressing fraudulent transactions are also not there. Undervalued was there, preferential was there, and the extortionate was there. Now they are adding the fraudulent transactions also into the individual insolvency related proposals. So all these are welcome processes. The direct dissolution was happening through the judicial pronouncements. it is now being brought into the code that in case the COC decides, the company can directly go to dissolution rather than going through the entire liquidation process from the CIRP. It can go to dissolution. Duplication between CIRP and liquidation processes, this is also there in the regulations, but they are also bringing it back to the code so that there is no duplication between the some of the actions under CIRP, some of the tasks under the CIRP or under the liquidation. Role of the creditors during the liquidation process, that's something which is a replacement of liquidator. It is already there in the regulations. They're bringing again in the code that the powers to replace the liquidator, that is already there in the regulations. Stay on the continuation of proceedings during liquidation process. This is something which is again the difference between the moratorium under section 33(5) and under section 14 was only this, that in CIRP even the existing proceedings were also, all litigations were also stayed. However, in litigation the existing proceedings were not stayed, and in this case now the existing proceedings will also be stayed. We are only trying to recommend that in case of any contingent asset, the liquidator should be empowered to start a fresh litigation without going to NCLT, for taking a approval to start a litigation. That is what the only thing that we should recommend on the continuation of the proceedings. Realization of security interest by the secured creditor, it is kind of more focused on that everyone should relinquish the security interest, and they should relinquish within time, and in case they don't relinquish, it will be considered as relinquished. However, we have seen that most of the banks, public sector banks, when they submit their claim, they say not relinquished, and later on they say relinquished. So because see, they don't get approval from their authorities, but this is also there in the regulations. It is, they are trying to just regularize it, and nothing more in this case. A role of the service provider as stakeholders, and like this is the one that the code was not providing, that before without issue of SCN any order can be passed, but now it has been empowered that without even issue of the SCN, any action can be taken against the service provider. That may be IP or that may be a valuer. So this is the regulation of the IPs. So I think this is what is the total, because the time is also up, and otherwise it becomes too boring. Any one or two questions can be taken up, or we can handle the questions separately. How do you propose now?
सर एक पॉइंट पे डिलीबरेट कर लेते हैं, जो IBBI को विदाउट इंस्पेक्शन एडिशनल पावर्स दी जा रही हैं टू गो अगेंस्ट IP और वैल्यूअर्स. सर इस पे शुड वी अपोज इट और शुड वी गो विद इट? इन माय ओपिनियन वी शुड अपोज इट.
No, actually, whatever we propose, that would not be seen as market view. That would be seen as opinion by interested parties. Even if whatever we propose, because see, in case government says that anyone who would be stealing the income tax, or they would select, and in case the vote is taken from the income taxpayers, so this is something that whatever we may say, the impact would not be much.
But still, I think
राइट दिया वोट करने का, तो हम वोट तो डालेंगे ही ना, चाहे वो जोन सी पार्टी ये कहेगी हमारे अगेंस्ट है जब हमारे साथ है, बट वी शैल वोट. तो सर this is we need to use our domain also. चलिए, सरकार को जो करना वो करेगी, हम अपना डोमेन यूज करते हैं. It was really a very marathon sort of deliberation by Anil ji mainly and Nilesh ji. Nilesh ji, please say word of thanks, and if any question is there in the chat box, we can take it out. I don't think so there is any.
Acha, so no questions, huh? From any of the
एक क्वेश्चन आया था, मैंने उसका आंसर दे दिया. No, there is no question.
Okay. ठीक है. तो thank you very much everyone, and special thanks to Anil ji. I think all of us have been enlightened by his views, and I think we will be, based on the recommendations made or the consensus which has been there, based on the same, we will be submitting our comments to Ministry of Corporate Affairs. I think Mr. Hemant Sharma. Hemant ji, you want to say something?
Yes, sir. Sir, there is only one question in my mind, with due respect, that there is one provision in the section 30A for the settlement for the promoter, even after publication of the EOI. In some of the cases, sir, we have been facing that the same problem that RP has run the whole CIRP, and later on the promoters come up with the 30A. So we are expecting that kind of amendment should come in there. That 12A is there. You constitute the COC before constitution of COC. You take it to a consent 90% of the person, and you settle the matter. There is no difficulty. But even after conducting the CRP, even after publication of EOI, inviting PRA and everything, and 30A is still there. So can 30A should not be, sir, amended in this proposal, because there it is silent.
I think you're talking about 12A, huh?
No,
12A.
Regulation.
30A, sir.
30A. Regulation 30A. He's saying regulation.
Regulation. Okay. I think हेमंत ये प्रमोटर के पास इतना राइट तो छोड़ ही दो कि जब तक रेजोल्यूशन प्लान अप्रूव नहीं होता और वो अगर सेटलमेंट कर ले, सेटलमेंट किसने करनी है? सेटलमेंट तो प्रमोट के साथ ही करनी है ना, सिक्योर्ड क्रेडिटर्स के साथ करनी है विद देयर 90% कंसेंट। आई थिंक विड्रॉल होता है तो आई थिंक शुड बी अलाउड। बट हाँ, आई थिंक जो पॉइंट आपका है वो ये है कि आपने पूरी प्रोसेस रन कर ली, प्लान भी अप्रूव, रेजोल्यूशन प्लान भी आ गया हाईएस्ट बिडर के फेवर में, अब आप वोटिंग करने से पहले आप सेटलमेंट कर लें। सीओसी से अप्रूव होने के बाद तो देन आई डोंट थिंक कि वो हो सकता है।
नहीं हो सकता है।
Sometimes court are giving these kind of liberties also, because court said it's not approved by us, so you can do the settlement if they want to do, because court do not want to pass an order on those things. Maybe that is my
सीओसी ने अप्रूव कर दिया, इवन उसके बाद भी सीओसी कैन पास द रेजोल्यूशन।
Yes, it has been.
Yes, sir, settlement करा है, ऐसे भी cases हुए हैं।
Okay.
Yes, sir.
It has
ऐसे भी cases हुए हैं। So therefore, sir, my view is this: अगर promoters को chance देना है, उनके पास रहना है, तो फिर 29A में दे दो ना। It's equally a bypass to the 29A.
Let me say one thing, Hemant, like 90% voting or 66% voting. I still believe that the 90% voting is more tougher than 66% voting. So if a promoter is accepted by 90% of the creditors, financial creditors, I think that cannot be considered as an inferior option with the creditors. Ultimately, we all are working for the creditors. Somebody may have secured charge, somebody may have exclusive charge, somebody may have something. If 90% are satisfied with the promoters and they are ready, they are having confidence on the promoters, I think the insolvency should be quashed. I think the insolvency should be.
I agree. For 12A, I agree, sir. For 12A, but 30A does not talks about 90%, 60%.
No, 30A also talks about the same. No, 30A and 12A are basically complementing each other. 12A is section and 30 capital A
is a regulation.
And the 30 capital A regulation is only just giving a little bit of detailed kind of process, like in case it is before the constitution, how it will be done. If it is after the constitution of the COC, how it will be done. So that is the only thing that is 30A is attending to. Ultimately, in case this committee is constituted, then 90% of the voting is required.
Right. So
90% of the people wants that this company should go back to promoter. Also, even if the promoter is giving 90%, satisfying 90%, the promoter is not getting any kind of waiver from government authorities, from operational creditors. So that waiver is also zero. All kind of litigation also would not be waived. All existing contracts will continue. So what is the reason? What is the reason that the creditor should not agree? Give me any reason the creditor should not agree, or give me any kind of stakeholder who is adversely impacted by this action.
Only the resolution applicant who has given the resolution plan.
No, RP is fee. RP is also.
Sir, RP
I'm saying in the lighter side, RP, because we indulge in the process to.
You don't get the credit. You don't get the credit for a
but you get the
approved resolution plan.
Money for the work also. And sir,
12A is there. I agree. Within 30 days you decided. It's a so long process. After EOI also, you are giving the chance to the promoter. That a little bit of some kind of pinch to the points you are saying to
like, I think when I said that there is no other person who is aggrieved with 30A or 12A other than the resolution applicant.
That is correct. Okay.
And the promoters are giving better than the resolution applicant, then only it is being accepted.
Yeah.
So,
हेमंत जी ये हर प्लेटफॉर्म पे इस इशू को रेज करते हैं. इनका मेन कंसर्न होता है कि आरपी की मेहनत सारी करी कराई बेकार हो गई. हेमंत जी कोई बात नहीं, वी आर मेंट टू नलिफाई आवर लेबर. तो
आरपी इज अ सर्विस प्रोवाइडर एंड
यस को पैसे मिल रहे हैं. और अब ये भी एक बात और ध्यान दो कि इस तरह की सिचुएशंस के अंदर आपके अगेंस्ट कभी आईबीबीआई में कोई कंप्लेन नहीं जाएगी, बिकॉज थिंग्स हैव गॉन बैक टू द प्रमोटर. तो जनरली जिस कैडर से कंप्लेन जाती है वो भी एक आपका रिस्क कवर हो गया. तो नीलेश जी प्लीज से वर्ड ऑफ थैंक्स नाउ.
ठीक है. ओके, थैंक यू वेरी मच अगेन अनिल जी, थैंक यू वेरी मच, एंड ऑल द पार्टिसिपेंट, मनोज जी, Mamta ji, everyone, thank you very much for participating in this program. And I think all of us have benefited because of what has been stated by Anil ji and the discussion which has taken place. Thank you very much.
Last में मैं एक बात सिर्फ
Manoj ji,
yes sir, please
say the final bye bye to everyone. I would like to add that it was a very, very pleasant and discussions with Manoj ji and Nilesh ji, and collectively we could say whatever we have learned. I think it must have benefited the listeners, and also my thanks to the entire group of associations for inviting me. And this gives me a pleasure, although it is 2.5 hours or close to 3 hours, and that to a working Saturday. But still, I definitely would like much more opportunities to interact and connect with the professional colleagues. Thank you, Nilesh ji, for the nice interaction and discussion. Thank you, Manoj ji. Yes, please.
सर लास्ट में एक बात मैं कहूंगा कि जितनी हमने डिस्कशन करी है, अब यू नो वी हैव सम कन्फ्लिक्टिंग सिचुएशन वेयर बाय वी से कि इट शुड बी एक्सेप्टेड एंड इट शुड नॉट बी एक्सेप्टेड. हम इंटरनली इसको आपस में बात करके सर से, अनिल जी से हम इसको बाद में यानी कि इनके साथ शेयर करके हम सब लोगों के साथ बाय मंडे शेयर कर लेंगे, सो दैट यू नो एज पर योर विजडम जैसा आपको लगे आप गवर्नमेंट को अपना रिप्रेजेंटेशन दो. पीछे जी ये देखा गया है कि जैसे क्रिप के अगेंस्ट, लिक्विडेशन के अगेंस्ट गवर्नमेंट ने जब पब्लिक ओपिनियन मांगा तो ज्यादा नहीं आया. तो यू नो ये मैंने स्टार्टिंग में भी ये कहा था कि बजट हमारा साल में एक बार ही आता है. ये 6 साल में एक बार ही इस तरह की हैवी अमेंडमेंट्स आई है कोड के अंदर, और यू नो इट इज गोइंग टू अफेक्ट अ लॉट टू ऑल द स्टेक होल्डर्स एंड वी आईपीज द मोस्ट, स्पेशली जो हमने 3-4 इसके अंदर अमेंडमेंट्स करी हैं. जैसे एक एडमिनिस्ट्रेटर की सजेशन बाई चांस सामने आई कि लेट आईपी बी अपॉइंटेड एज एन एडमिनिस्ट्रेटर. तो यू नो तो प्लीज हम अपना शेयर करेंगे एज पर योर विजडम. आप इसको आगे गवर्नमेंट के साथ बड़ा ये फॉरवर्ड जूट करना. इट इज वेरी वेरी इजी. एक ईमेल है उसके अंदर आपको पोस्ट करना और रीजनिंग देने का क्यों कर रहे हैं, दैट इज ऑल. और अनिल जी वी आर इंडेबिटेड. मैं तो ये कहूंगा मैं ही नहीं, हमारी आईपा एसोसिएशन ही नहीं, सारे के सारे आईपी जिन्होंने आपको सुना और बाद में जो आपको यूट्यूब पे सुनेंगे, इतने बिजी होने के बाद, इतने सीनियर होने के बाद हम आपको जितना भी शॉर्ट नोटिस देते हैं, यू ऑलवेज वेलकम कम एंड यू ऑनर आवरसेल्फ. आई कैन वेरी वेल अंडरस्टैंड कि आपको इस समय 2.5-3 घंटे लेने के लिए अपनी सारे के सारे प्रोग्राम रीशेड्यूल करने पड़े होंगे. एंड आई कैन सी द पेन इन योर फेस आल्सो. यू नो इट्स नॉट इजी टू स्पीक कंटिन्यूअसली फॉर 2.5 and 3 hours. बट सर हमारा शायद आपके ऊपर हक है. आप भी आईपी हैं, हम भी आईपी हैं, आप अच्छे एक्सपीरियंस हैं. एंड मी एंड निलेश जी आर रियली थैंकफुल टू यू ऑन बिहाफ ऑफ आईपा. ममता जी की शायद तबीयत ठीक नहीं थी, दैट इज व्हाई शी लेफ्ट. तो थैंक यू वेरी मच. थैंक्स टू ऑल पार्टिसिपेंट्स आल्सो. कीप joining, keep encouraging us, and keep showing your videos also. Thank you very much.
Okay, with this we close today's session. Thanks.
Thank you.